Ntate Inana dumela.
Dumela Morenaka, le kae?
Re teng le kae morena?
Di siame ntate.
No, re leboha.
Ya. Utsuile.
Ke tswile man meeting ona ne ke sa se aware hore o tlo ba hona fandaga ke a bona o ne le di-email tse di communicated.
But communicate very late.
Yeah, no, that was really late.
Yeah, no, we see me in that.
No, we'll see that.
Oh, sure, Papa.
And that is some dumela.
Ntate Masipa le ka Morenaka.
Re phetse re ka botsisa le ntate.
Ke be le kwele mokone.
Thank you, man.
Ila ntate yena Inana.
Brena.
O jwa monna matati le kwa.
Wa steke wa hesel spread ke la ke ya tlinda da mathata le kae du.
Ntate re utlwa moya fela le serame se hlang ona heshele mo. Rotla maphako mona ramesa mo.
Yeah.
Oskata.
Utla ba skata. Uskata.
Ana le ntate Masipa letsa forum ena caucus ya DA ne.
Yeah. Caucus ya batle.
Oh. Batso caucus ke eng ka Sesotho?
Ring.
Momori.
No. Ya ke momori. Ke gossip. Momori ke gossip. Or allegation. Ke allegation because momori ke ntho e buang but has not been proven. Okay.
Momori ke conspiracy. Ona le momori mono wa hore no Masipa le Inana ba tla o fetola le abua Jonathan.
Yeah.
Ona le momori
Wa le abua Jonathan wa le suit.
Ona le momori mono wa hore Inana le Masipa ba batla o fetola mmuso wa le abua Jonathan.
Yeah, but how about the dude? How about the dude?
Meeting was once about Talega 9.
Recall that notification, but I emphasize utatala ka
10. Yo. Yo. There was notification here about the tenant na kya bono one romela yo.
Yeah, it running the barney the document is in a barney link on. It's not exactly what happened there.
No, give more in.
Yeah, give more. Nanek na Balar Lelau had really northwest. These are the areas that we visited, and these were the issues that were raised.
Momori. You must be careful, guys, because they are underage listening on Facebook here.
Yeah,
Momori alone.
Yeah, Bagadi di Manela. We are not hiding this one. It has to be a public consumption. Ulukile wondat.
Thank you.
No, I'm struggling to find the Sotho words for caucus.
Can I give you a Xhosa word for caucus?
What is it?
Imbunga. Imbunga.
No, but so it's never been translated to English. Can you spell the Impunga?
No, kupa hina na uspelele yona mna. Umpakela mathatha. Kupa hina na uspelele yona. Imbunga. M-I-M-B-U.
Is it P or B?
B.
Okay.
Bunga.
Okay.
Bunga.
Impunga with a K.
Yeah, Mbunga. No, with G.
With G, then it's a flower.
Is it what?
It's a flower.
Mm-hmm.
No, it's a flower.
The flower. That's a dictionary. How you?
Make a guess. May Albertina? May Albertina Dumela? Hello, colleagues. Is the meeting still on? Good morning, colleagues. It's 5 minutes past 10. Is the meeting still on ahead?
Morning, honorable members. We're just still waiting for the chairpersons to join in as the meeting is still going to carry on. Sorry for that, for not announcing that.
Noted, thank you. What do we do with this shenanigan here?
Good morning, honorable members. Morning, Secretariat. Are there any apologies from the Secretariat of Employment and Labor?
Morning, Chair.
Good morning. Any apologies on your side?
Oh, yes, Honorable Chair. We've got Honorable Nonsele, who is the acting chairperson. Firstly, the chairperson is off sick of the Employment and Labor. So we have got an acting chairperson, Honorable Nonsele, but he also is in transit. He said he's going to join in later. That's the only apology that I have. And also Honorable Makubela from Employment and Labor is struggling because she is also driving, but she's in and out of the meeting, Honorable Chair. Thank you.
Thank you. Mam Kagaza, any apologies?
Thank you, Chair. Good morning, Chair, and members and colleagues. Chair, from Agriculture, I've got the apology from Tatu Kapa.
Recording in progress.
Tatu Kapa is attending the Ethics Committee. Uma Muchwete is attending to ISAR's issues. And then Uma Mashlat is attending PC on higher education. Tatu Kapa was attending to prior engagements that year. Minister is not available due to unforeseen engagement, and DM Kappa is also not available due to prior ministerial engagements, and Tatu Kruka is traveling, Chair, so he won't be able to connect. Thank you, sir.
Thank you, Mamuka Kaza.
Sorry, excuse me, Honorable Chair. Employment and Labor, I forgot, Honorable Chair. There was also another apology from Honorable Cardo. Sorry, I forgot about that, Chair.
Thank you. Any further apologies?
Chairperson, Honorable Mahlo, here I will request your humbleness, Chair, that at 12:30, I need to attend another standing committee on management of Parliament.
We will try and gallop with speed so that we are done by 12:30, Honorable Mahlo. So do bear with us. Honorable Masipa.
Chair, good morning and good morning, colleagues. I have got an apology for Member Bama. She is not well. She will not be able to attend. Chair, further, I've got just one concern before we start the meeting. Is this meeting a joint meeting? Because our notice was that this is a Department of Agricultural and Reform and Rural Development meeting.
It's a joint committee meeting, Dr. Masipa.
Chairperson.
Yes.
Honorable Makubele PP here. I just wanted to apologize in advance. I'm actually driving to the airport, so in case I'm on and off, may I be forgiven? But then I'll make sure that I'm in a meeting where possible.
Thank you, Honorable Makubela. Honorable members, those are the apologies. Let me tender my own apology, as today is our day of prayer. So at 12 o'clock, I shall request to be excused, and Honorable Kape will resume as chair to conclude the rest of the meeting. With that said, I should also apologize with the technical challenges I've had this morning in trying to log on, but I'm happy that I'm sorted now. Therefore, good morning, goeiemorgen, molweni, dumelang, bagaetsho. Allow me to welcome you all to this Portfolio Committee meeting of Agriculture, Land Reform and Rural Development Portfolio Committee this morning. I am always reminded of the wise words of Comrade Dala Oma, our first Minister of Justice in a democratically free South Africa, when he said, we must not pass laws for what we already have the power to do so, close quote. I say this with the content of this high-level panel process, as a number of the findings and recommendations of the assessment of legislation passed since 1995 requires no new legislation. On the contrary, it requires good citizenship, a commitment to the founding principles of our democracy, with the national reconciliation, national building, and social cohesion. And moreover, it requires a change in attitude from the slavish colonized mentality where we become wholly dependent on government grants in aid, philanthropy, and third-party assistance. Honorable members, let me start with the last point. Our history is replete with stories and examples of individuals who have defied all odds to overcome all obstacles and made a success. We need to understand the mass psychosis of centuries of colonialism and its impact on the minds of our people. I have made this point before on a number of occasions, honorable members, but it is so intrinsically related to the challenges that we face in the agri-sector, especially in deep rural areas. There are many who have embraced national reconciliation, by the implication have been model citizens in whatever area of life they find themselves. It is therefore those who have made or who have been defiant in the face of the imperative to embrace national reconciliation. They have held onto labor practices that are dehumanizing and violate the current legal prescripts. This has been particularly rife in the areas of ESTA and LTAs, where poor government administrative capacity has served the cause of those unwilling to transform. Honorable members, allow me to make one point that we cannot year in and year out regard the immense potential that the agri-sector has for job creation, poverty alleviation, and economic growth. We must leverage the collective will, resources, skills, experience, and wisdom to effect change. Where there is no transformation, to give up privilege, no amount of legislation can bring the desired change. Honorable members, the agenda for today is that we will be having two presentations from the high-level panel as well as from the Presidential Advisory Panel. Allow me to therefore invite our first presenter, which will be Annika Klassen, on the high-level panel assessment of key legislation and fundamental change. She will be followed immediately by the presentation from Professor Ruth Hall on the Presidential Advisory Panel. let us, having concluded that, we will also have a set of minutes that we will be adopting. I therefore take the privilege to inviting Annika Klassen to present before the Portfolio Committee on Agricultural Land Reform and Rural Development on the high-level panel. I thank you.
Thank you very much, Chair. And may I just start by saying, I'm sure some of you are surprised to see a white woman presenting on the high-level panel and a person whose surname is Claessens. But I was just one member, albeit I was the chair of the land subcommittee of that panel. And among the other members of the panel, we heard thousands and thousands of farm workers testify about the terrible conditions in which they continue to live and the failure of government to actually enforce the law. And just to say, all of our work is contained in this report, which is freely available from Parliament and available online. And then just to say that this presentation is especially meaningful for me because I was the General Secretary when I was very young of the Paper, Wood and Allied Workers Union. And we organized in Piet Retief, and some of the shop stewards took me to stay on their farm, Pampunkrol, where they were labor tenants. And I was exposed to the extreme violence in that area, Piet Retief, Wakkerstroom, Ermelo, by white farmers. And I've been watching press reports ever since. And there certainly is an ongoing crisis there with that kind of violence and eviction continuing into the present. But without further ado, let me share my screen and start my PowerPoint. So I hope you can see the PowerPoint.
Yes, we can see it, and if you can put it on
point of order, Chair.
Yes, Dr. Masipa.
Chair, I don't know if I missed the presentation. I do not have the presentation with me. Maybe if I missed it, can I request that we be sent the presentation? Please, Chair. Thank you.
Yes, the presentation was sent to us by Mema Ledu. We'll request that it must be circulated to those that haven't received it. Mema Ledu, please send it again, and perhaps send it directly to Dr. Masipa.
I must apologize that, in fact, I haven't sent the presentation because I've just finished it, but I will send this one immediately that we are finished, and hopefully it can be circulated. And I do apologize for that. Okay, and just to, so should I begin?
Yes, please proceed, Mayor Annika.
Thank you. Just to say that I'm going to stick very closely to the panel findings, and I'm basically, this PowerPoint is comprised of extracts from the high-level panel report, which you can all find at that at the website, parliamentary website. And where I make remarks that are not part of the panel, I will let you know. And to just say that Professor Hall and I discussed it, and because there's a lot of similarity between what the high-level panel recommended and what the Presidential Advisory Panel recommended, we decided that I would focus strongly on the actual input, and she would provide certain kind of updates of what has happened, because you must remember that the high-level panel reported in 2017, so lots has happened since then. So I'm hoping that this will, oh, why can't I go to the next slide? Okay, I'll go to the next slide here. So to say that Parliament passed 2 pieces of legislation intended to give effect to section 25(6), which provides for tenure security. And those 2 pieces of legislation were particularly about people living on so-called white farmland. And those were the Extension of Security of Tenure Act, which applied to people living mainly on farmland, and then the Labour Tenant, the Land Reform Labour Tenants Act, which applied to a specific subcategory of people, mainly living in KwaZulu-Natal and what was then Eastern Transvaal, now Mpumalanga, people who worked on farms in exchange for access to land. And often those people are people who had lived on those farms and continue to be people who've lived on those farms since long before the white owners arrived. And this just sets out that Esther deals with the relationship between farm dwellers and landowners. It provides a set of procedures to try and limit the problem of unlawful eviction from farms. And the Labour Tenants Act really applies to the smaller category of people with very strong historical rights to certain productive parts of those of farms. And to just stress that both of these acts have redistributive components, in that Esther provided for on-farm and off-farm settlements, in terms of which the state would provide grants to acquire land, whether a portion of the farm or areas off the farm, where Esther occupiers could have secure rights to land in their own names. And the Labour Tenants Act provided that Labour tenants would be able to acquire the parts of the land that they had always farmed, regardless of the white title that was superimposed on their pre-existing historical rights to that land. And I think everyone is probably familiar with the fact that Labour tenants are the one kind of exemption that relates to the question of compensation, because often the title deed holders have never really had full use of the land that Labour tenants continue to farm in exchange for their labor on those farms. So just to go back to some of the history, and all of this is taken directly from the panel's report. This is just cut and paste from the panel's report. And this goes back to the 1997 white paper on land reform, where they discussed that issue of having both off-farm settlements for the purchase of land in farming areas where farm workers could have ownership of that land, but also on-farm settlements where a portion of the land of the farmer would be excised from the farm and transferred to the farm workers. And then Section 4 of Esther, and this is very important and we'll come back to it repeatedly, requires the minister to make available subsidies in support of these various types of settlement options. And similarly, the Labour Tenants Act provides for the minister to make funds available to settle Labour tenants' claims to their underlying ownership of those portions of farmland. Now, as you will all know from your oversight visits, despite these ambitious early laws in 1996 and 1997, evictions have continued apace. And this issue has been highlighted through numerous commissions and reports. The Human Rights Commission had hearings and issued reports in 2003 and 2007. And when they asked why is Section 4 of Esther not being used to acquire land for farm workers, they were told by the then Department of Land Affairs that the process was slow because it required the minister to approve each transfer, and the Department of Land Affairs was then requested statistics on the number of Section 4 subsidies approved, and noted that these were not forthcoming. And the report says that this highlights a persistent concern about the unavailability of reliable data from the department as a basis for Parliament or anyone else to assess whether laws are being properly enforced and implemented. The The Human Rights Commission findings, again, this is directly from the report, found widespread non-compliance with ESTA, a disturbing lack of knowledge of ESTA by all role players. For example, it is illegal for a farmer to evict a farm worker without a court order and without following ESTA, and the Act provides that those farmers can be arrested. But no police know this. They don't know that actually it is a crime for farmers to evict people without following the terms of the ESTA law. And therefore the teeth of that provision are simply not available because of this failure to inform the police, who are the first port of call in these issues, and the people who are on the ground in rural areas, of the rights that farm workers have and the procedures that the Act lays out. And the report says that there's a complete lack of compliance with the legislative provisions of ESTA, and that is partly why farm workers are continuing to be evicted in terms of common law, where actually there's a statute that provides certain protections precisely against common law evictions. They also found that a lot of evictions took place when farms changed hand, and a failure by the state to adequately train its officials to implement, but also just to understand the legislation, and that there was a lack of housing for farm workers, and that the Department of Housing seemed not to understand that its mandate to fulfill the right to housing also applied to people living on farms, and that there was just no emergency accommodation for when evictions did take place. But, and here is a critical point that both the high-level panel and the Presidential Commission highlighted, the key issue seems not to be these technical problems, but a lack of political will to implement laws that provide services to farm workers and dwellers, and that this was the primary reason for the lack of enforcement of these laws. A lack of care for the basic rights of the most vulnerable in our society. Now, the Green Paper on land reform in 2011 also recognized that there was a terrible problem with farm evictions, and it categorized the problem, and this is the department's own Green Paper, and this is a quote from the Green Paper, as a problem of total system failure, where it said that it's not the fault of ESTA or the provisions of the law, it's a problem of weak enforcement of legislation by law enforcement agencies, the lack of organization on farms, and a poor or non-existent monitoring of the actions of the state. And that all of that total system failure, in which Parliament must recognize that it is part of the problem for failure to fulfill its oversight function, has led to these ongoing evictions of farm workers and labor tenants. And the department introduced a policy in 2013 where it acknowledged that farm workers and dwellers continued to be the most tenure insecure and often evicted, despite the measures meant to mitigate this. It chronicled the failure of farm worker equity schemes those failed to provide any real benefits for farm workers and dwellers. And it highlighted the failure of the inbuilt aspect of those laws to provide for redistribution of land to farm workers and labor tenants, that those provisions were just simply not enforced, despite there being a budget and the legal power for those subsidies to be provided. And it recommended that the department should make available a dedicated, I can't see the whole of my slide, but dedicated, I presume, budget and process to secure rights of farm workers and labor tenants. But instead of enforcing its own recommendations, the department then took a detour and it went into a discussion of a new policy, the 50-50 proposal, which was not contained in any law, and funds that were meant to have been, which were in fact ring-fenced by law to be spent on acquiring land for farm workers and farm dwellers, were diverted to some of these 50-50 schemes before that policy was jettisoned as entirely unworkable. So, despite all of these reports and its own reports, the failure of enforcement and implementation was simply not addressed. And the failure of the department's own finding of total system failure was not addressed by the department. So the HLP, I'm going to try and close something so I can see all of these slides. The high-level panel finding was that there's widespread agreement that the department hasn't allocated resources to implementing these two pieces of legislation, but also that the department had never produced comprehensive or costed plans to implement the Labour Tenants Act or ESTA, and that there is evidence that a broad range of government officials, including critically the police and even magistrates and prosecutors, do not fully understand the legislation protecting farm dwellers. So the high-level panel recommended that government needs to develop and implement a training program for the South African police services, prosecutors and magistrates on understanding, interpretation and implementation of ESTA and the LTA, and that the South African police services need to ensure that ESTA violations appear in the database of the South African police services. So until there's a database of evictions and until training material is made available, including judgments of the Constitutional Court and of the High Court that set precedents that the courts must follow, until those basic things are made available to the police and in rural courts, there is no hope that this legislation will be enforced. And the high-level panel also recommended a national register of farm dwellers and to record all their off-register rights, and that should be tied to another fundamental recommendation of the high-level panel, which is a national register of all off-register rights, because the majority of South Africans have no recorded rights to their property. Whether that is people living in the former homelands, whether it's people living in informal settlements around the cities, whether it's people who have lived for decades or even generations on white farms. And as we will discuss later, that's not an oversight. That was by the design of apartheid law. So all of those people without any kind of recorded land right, we're not talking about title deeds here, we're talking about recorded land rights. It's very, very difficult for them to enforce their rights in the face of threats of eviction. And then the high-level panel recommendation was about a review of legal assistance to farm dwellers, where in fact there was a court case that set the precedent that government must provide legal assistance to farm dwellers faced with eviction. But the mechanism for providing this legal assistance was sort of given to private law firms. And here the recommendation was that that mandate needs to be returned to the Legal Aid Board, and that would be cheaper for government. I'm not sure, but I'm sure the chair can tell me. I think some aspects of that recommendation have since then been fulfilled. And that this critical recommendation that we need an information campaign about farm workers' land rights and communal land rights. And that information campaign needs to be on radio and in newspapers. And it needs to go to farming communities, but it also needs to go to farm workers. And what we need are posters about the basic rights that people have in terms of ESTA and IPILRA. And that if you had even posters setting out the basic rights in every police station, in every post office, in every municipality, traditional council office, and public space, that information alone would change the balance of power in rural areas and ensure that we don't have evictions taking place because of ignorance of the law, whether by farm workers themselves, whether by the police, or by farm owners. And then this critical issue here, where lawyers have gone into court and had to give the magistrate or the prosecutor copies of constitutional court judgments or high court judgments, because those magistrates and prosecutors didn't have those judgments and didn't know that the law had been developed. So really we need a process of informing and training judicial officers and the police. And then at that time that the high-level panel reported, there was an ESTA amendment bill, and the panel made recommendations that certain of the amendments then being considered did not address the fundamental problems. But I won't go into those detailed recommendations because that amendment bill has since been passed into law. So I'll just come to one of the recommendations, which is a more general one, which was that a dedicated budget and human resources must be ring-fenced for ESTA implementation and for monitoring and accountability of those Section 4 grants, which are the grants to acquire land. Sorry, I'll just switch that off, sorry. I'm sorry about that. Okay, so that's the recommendation that we have a detailed, a dedicated budget. And then also, and here is the question of oversight and enforcement, that if the department doesn't provide the information, no one can provide, no one can exercise oversight. So that the department must set up and maintain district registers of Section 4 of ESTA cases, and that consideration should be given to rezoning land on which farm dwellers reside from agricultural land to residential land in terms of the Spatial Planning and Land Use Management Act. So if you had an off-farm settlement where land was expropriated from, say, 4 adjoining farms to create a farm worker village, that needs to be rezoned as residential land rather than left as agricultural land. And that long-term occupiers who are currently living on farms should have their tenure security strengthened for them through being able to acquire title or equivalent secure rights either on the farm or off the farm. So the panel also made recommendations about the enforcement of the Labour Tenants Act. Now, the panel reported in 2017, but the Mwelasi Constitutional Court judgment about labour tenants was handed down in 2019. And that judgment is a stinging rebuke of the department's failure to enforce the Labour Tenants Act, despite that act being enacted to give effect to a constitutional right, which is a right to tenure security. So we have now the Mwelasi Constitutional Court judgment, which so despaired of the department's capacity to abide by the law, and frankly, so despaired of there being any proper oversight exercised, that it established a special master who must now report on the remedial actions, both to Parliament, but also to the court. So that's a very far-reaching judgment. At the time, the panel recommended that Parliament must carefully monitor the department's progress on implementing the Labour Tenants Act. A comprehensive, properly costed and resourced implementation plan for the Labour Tenants Act is a critical starting point. Until that has been developed, progress is likely to remain haphazard, under-resourced, and poorly managed. The risks around poor implementation need to be fully assessed and managed, learning lessons from past failures. Well, that recommendation was overtaken by the Constitutional Court judgment. So now I'm drawing towards a conclusion, and I'm going to focus on the conclusions to chapter 3 of the report, which was the main chapter about land. And here the report said that the failure of land reform is not really so much about the need to pay compensation or the need to introduce legislation, but about the problem of corruption by officials, about the problem of the diversion of the land reform budget that's meant to be spent on securing the rights of the poor and the vulnerable to elites, and on a lack of political will, together with a lack of training and capacity. And the panel really highlighted that there are sections in the Constitution, 25.5, 25.6, and 25.7, which provide for positive rights to land. And 25.6 is the section that deals with tenure security. 25.5 is about equitable access to land, and 25.7 is about restitution. And it finds that although there have been some laws to enforce these positive rights, those laws have been ignored. And they seem to be under attack from a policy that has changed direction from trying to enforce the rights of the vulnerable to instead redirect the benefits of land reform to specific elites. And yeah, the other problem, the specific recommendation in relation to farm occupiers and dwellers was not so much the terms of the law, although the panel did recommend some minor amendments, but it said that those amendments mustn't detract from the overarching problem, which is that the existing law needs to be properly enforced, particularly its neglected redistributive components. That's the section 4 of Esther and the provision to obtain land to fulfill Labour tenants' claim. And it made two major recommendations, one about a new land framework law to sort of coordinate all the disparate elements of land tenure, which I won't go into here because the topic here is more limited and specifically focused on farm workers. But the other was about a new Land Records Act, where what we have in South Africa is a range of land rights that coexist, and that although vast swathes of South Africa fall under title deed ownership, that doesn't deny that there are other people with coexisting land rights. And since the beginning of time, and even as a feature of Roman Dutch law, it was always recognized that there are coexisting rights on land, even where there is title deeds. There were laws and precedents to protect the white Baywooners who lived on the early farms. And there are other laws and legal precedents such as prescription and beneficial occupation, which recognize the de facto rights of people who live on land that may be registered in the name of other people. And this new Land Records Act talks about the need for those rights to be recognized in our deeds registry system, not necessarily as full title, but in a way that reflects their true nature, their shared nature, particularly in respect of customary ownership. But yeah, I mean, you could ask questions about that. But there's a whole chapter on that proposal, which is probably beyond the scope of the discussion today. And the report highlighted that because apartheid was designed to recognize only white ownership, Black property rights had to exist despite the law, and yet de facto, Black people occupied land and de facto owned it, despite the overlay, the racial overlay of a segregated system of property rights. And so you had Black people confined to conditional use rights in the former homelands, for example, where they had PTOs, whereas in fact those people were owning and bequeathing that land.
3 minutes remaining. Can we conclude?
Okay. So, you know, the early policy looked at trying to recognize all of those coexisting rights and give them legal recognition, whereas current policy seems to default to a kind of winner-takes-all situation where title deeds trump any other form of land rights. I think I've only got 3 more slides. So this talks about the early laws again, and the panel saying that recent land policy seems to be driven by opportunities for political alliances and elite enrichment, rather than focusing on the structural drivers of enduring inequality and ownership. And again, we have this problem of the failure of implementation and the failure of setting aside funding, dedicated funding to fulfill legal mandates. Now, here we come really to the role of Parliament, and the panel did make findings about the need for the role of Parliament to be strengthened as a representative of the public. And it talked about its oversight mandate, and that Parliament needs to ensure compliance with legislation and implementation, and it needs to develop strict enforcement of penalties for non-compliance. Now, Parliament's failure to ensure adequate oversight has been exposed by 3 very damning court judgments that were all given after the HLP reported in 2017. We have the Lamosa judgment about restitution, the Mwelasi judgment about labor tenants, and the KSEC judgment about the Ingonyama Trust. Now, in all 3 of those judgments against the department, the courts went much further than they normally do, in that they created a structural interdict and they imposed special masters or other mechanisms whereby the department not only has to report to Parliament, but it has to report back to the courts. And that really is a terrible indictment on the failure of oversight by Parliament, because there you have the judiciary stepping onto the preserve of the executive and the legislature. And it does that with extreme reluctance, only when there is a record, an established record, as there was in all 3 of those instances, of the executive failing to enforce laws that give effect to constitutional rights. And this is the last slide here, where the panel says, it raises the question of how the executive is able, simply put, to get away with poor implementation. And the panel recommended that Parliament's interpretation of its power of oversight is too limited, and it needs to ensure strict enforcement of penalties for lack of performance by the executive. And I leave you there, Chair. Thank you.
Thank you, Nika Klassen, for the presentation. Honorable members, there you have the presentation from the high-level panel. We'll now open the session for questions of clarity and discussion. Any questions, honorable members? Honorable Klabe.
Thank you, Chair. Chair, I'm on the road and my network is not that stable, but I have stopped just to do the interaction with this presentation. Let me thank the presenter for an elaborative presentation, Chair. I think instead of questions, I would do some comments. Chair, my take based on the oversight that we have just undertaken is that we have a long way to go as people of oversight, especially on issues of labor, tenants, and farm dwellers. It's very disheartening to find out that there's no political will, according to this report, and not enough is being done, especially on enforcement. And I'm sitting here and asking myself, Chair, for what more needs to be done if we have to say we are holding the executive accountable. Chair, the most crucial matter for me here is the issue of the legal representation of farm evictions. And I would agree with the high panel report that that matter be removed from private law firms, probably to the legal aid boards, with enough oversight there, because Chair, what we found out on the ground, where the farm dwellers don't even win cases against their employers, is disheartening, because the lawyers that are being used are lawyers that are members of society in those little small towns. They know each other, they know their employers, they know the magistrate and everything. It's a very painful situation. So as Parliament would want to accelerate that issue, that let the legal representation of farm dwellers be removed from private firms, and it must go to legal aid boards. To Chair, for me, and this will go directly to your portfolio committee, the Ngonyama Trust Board court judgment, the recent one, cannot be left unattended based on what has just been alluded now. We would have to have a meeting on this one and come up with a plan. How do we help and hold the executive accountable in the implementation of what the Masters has said on this judgment? So, Chair, I'm just like, it's like we have not done enough for the farm dwellers, for the labor tenants. These people, this section of the society really needs attention. We would want, and I was thinking, Chair, it's better with issues of labor. They know which office to go to when they need their compensation, when they need their monies, when they have been chucked out of work. But when they are evicted, they just lay on the street. And it's very painful to even have this acknowledgement that our police and even prosecutors don't understand the ESTA laws. So we really need to come up with a plan decisively. How do we deal with? And I agree with the issue of information sharing, that let's go all out and make sure that information gets out there, but have a tangible plan that will yield results. Thank you, Chair.
Thank you, Honorable Metape. I see the hand of Honorable Ntate Masipa.
Thank you, Chair. Chair, also, I don't really have much of questions, but to really commend the work that was done by the high-level report. But however, just thinking about it, I haven't really gone into detail in terms of studying that high-level report. I did, kind of go through it, when we started this term. The concern for me, Chair, is that, the report is quite, highlight the scathing, court outcome. And the issue is that I think, we will be found to have really failed the same efforts that the higher level report has gone into in terms of highlighting the gap. And I'm talking about us as the portfolio committee or as members of parliament in terms of doing our role around oversight. And I think that's the area, Chair, that we need to really review and reflect quite deeply, because the legacy report was there. And I really think, Chair, that we missed the boat there in terms of really looking into it. Because if you look at all this that has been presented today, there was really no need for us to go on oversight, because the issues that are captured here are the issues that we picked up on oversight. However, maybe one question that I want to sponsor is that on that high-level report, I cannot remember the recommendation in terms of timelines around really delivering on this number of recommendations that were given, because I think that would have been really very, very important, that we use the timelines that we're given as parliament to ensure that we hold the executive to account, because the gap here is holding the executive to account. And also when we plan our programs, to really just make sure that all the, call it, I can't remember the name quickly, but all the outcomes that the department from their APP are putting together, that we are able to ensure that each and every area is monitored to ensure that this kind of issues are not really left to the last minute to really kind of address them. I mean, you look at the issues of subsidy, for the Esther tenants, and the issue of knowledge, the issue of political will. This was just clear and evident during our oversight visit. And also, really, Chair, I must just emphasize this, that even this meeting, the planning of this meeting, it starts with the planning. The meeting was really given a short notice. We were not really prepared. We're not even sure if the meeting is between 9 and 12 o'clock or 10 and 1 o'clock. So it starts there. If we do our planning properly, surely, Chair, we will be able to hold the executive to account. But if we don't do it right, I've got 3-4 members that are not here. They're supposed to be deliberating and engaging on this particular, topic, which is a very, very critical. It's a very, very critical topic that, as a country and as parliamentarians, really, Chair, we need to really look into it and ensure that we really bring justice to our people that are really struggling. I thank you, Chair.
Thank you, Honorable Ntate Masipa. On our side, we will make sure, honorable members, that all the program for the meetings of the Joint Portfolio Committee meetings will be circulated, which will all be sitting on Fridays up until we conclude our report and we do finally adopt it. So we are apologizing if there was a lack of communication for this meeting, but every Friday we shall be having meetings to try and ensure that we are able to conclude this work on time. Honorable Neba.
Chairperson, thank you very much, and greetings to the colleagues and to the officials. Chairperson, let me welcome this presentation by Mrs. Anega. The one point I want to raise, Chair, can we further get a clarity from the presenter about the the company that is called ZZ2. The ZZ2 is said to be benefiting the elites at the expense of the farm workers. Can you elaborate and clarify that? Because there is a relationship of the premier and the president that they are getting the advice from this ZZ2 company. Can we get the clarity on that? The second one, Chairperson, that I need to get the clarity is about the failure to understand the LTA and ESTA. There needs to be a training program provided to subs, to prosecutor and magistrate. What it lacks to give a clarity is who has to coordinate and provide that training. Because indeed, these sectors, that is the police, prosecutor, and magistrate must have the understanding what the LTA and ESTA is there to do. The other question, Chairperson, is to that before the eviction notice is issued or is implemented, they must first send that notice to the DG. Can we get, excuse me, can we get the understanding if is that the standard procedure that is happening? Because when we were on our oversight visit, not even the courts were informed about the eviction, and even the tenants were never getting the support from the Department of Labor. The last one, Chairperson, is what is it that must be done to the Department of Agriculture that is said that it has failed to provide mediation between the labor tenants and the farm owners to avoid the conflict that is happening in that community. Thank you, Chair. Chair, I'm done.
Thank you, Honorable Inana. I was muted there. Honorable Mtabe.
Thank you very much, Honorable Chairperson, and good morning to you and the honorable members, as well as the officials that are present in the discussion. Let's welcome the report. My issue, Chair, is one comment and maybe a clarity-seeking question. The comment that I'm starting with is the issue of the APP or the performance system that is being performed or developed for us to do our oversight work over the executive and to hold the departments accountable. The systems, the manner in which it's designed does not talk to the reality in terms of what is happening on the ground. This as well is being confirmed by this high-level panel report that there seems to be a disjuncture between what we oversight and what is being presented as performance by departments to the portfolio committees in terms of us playing that oversight role. I think there has to be a mechanical restructuring of how can we therefore have a performance that talks to what is happening on the ground. That has been confirmed by the number of issues that we have picked up during this joint oversight visit to the country. The last point, Chair, which I would like to get clarity on, it's on the question of the corruption of officials. The statements seem to be too general. I'm not expecting that this report should talk to investigations, but somehow should be reflective of in which areas that these officials are corrupt I might make an example of one of the things that we picked up, that in land claims that were forwarded by applicants, people who are then on the list of claimants are not the ones that have originally put up the application. So that has an element of corruption. If maybe the presenter can clarify that issue for us. Thank you, Chair.
Thank you, Honorable Mtabe. Honorable Mkonto.
Thanks, Chair. Good morning to you, Chair. Good morning to honorable members and the officials. Chair, I have comments and questions. And I have to welcome the presentation. It's quite informative, but there are loopholes that, or there are things that I need to be clarified on. Chair, there is one recommendation that says SAPs and NPA and magistrates should be trained on ESTA and LTA. I don't know, Chair, if that, because what we observed during the oversight visits is that another factor is the accessibility of these services to farm workers and farm dwellers. They are very far from the police stations and so forth and so forth. Some where they stay, there is no network, there is nothing. How could that how could they be assisted in as far as that is concerned? And that maybe during that training, say it's a comment, because SAPS has been complaining in all our engagements that Bona, they exist to implement policies that we approve as parliamentarians. Maybe during those trainings, they will be able to tell us as to exactly which clauses need to be amended in these two pieces of legislation. Hence, I support this training, because somewhere, somehow, we have to find each other. Because their scapegoat is that, no, we don't change the law, we implement. It's up to you to go and change these laws. Maybe during those trainings, they will be able to tell us as to exactly which parts of those laws needs to be amended for them to perform their duties efficiently and effectively. Chair, I agree that there is no political will. Today's meeting is evident to that. We are having members that just decided not to attend this meeting, and we don't know what are the reasons. And to say, I have never seen a white farmer arrested or convicted for transgressing the LTA or the ESTA. You will maybe the system waits for a person to die. Is then that maybe a farm will be given a jail sentence of 6 months that he or she has killed someone. Them transgressing, they do it almost every day, and the presentation talks more on the evictions, and I did not hear as to exactly what does the presentation say about the farmers creating an environment that is not conducive for living, that constructive evictions, as to how can law enforcement agencies deal with farmers that deliberately engage on constructive evictions. Lastly, Chair, as long as we are having people, landless people, and people owning a vast vast pieces of land in this country, we'll always have the power balances. The power is not balanced because the land ownership will always tip the balance of power in favor of the landowners. There is superiority complex that we have to deal with, and dealing with it is to balance the land ownership amongst the whites and blacks in South Africa. We have to think broader than what we are seeing here. A person who doesn't have even a hectare of land cannot stand up against a person owning more than 1,000 hectares of land. We have to be realistic, because now we are not realistic. We want a person who doesn't have even a half a hectare to stand against a person owning thousands of hectares of land. It's impossible, Chair. That's what, as politicians, if we really have a political will, that is what we have to look at, as to even if you own 1 hectare of land and a person who doesn't own land at all, what is your attitude towards such a person? Thanks, Chair.
Thank you, Honorable Mkondo. Agbare Breed.
Môre, voorsitter.
Hoe gaan dit vandag?
Goed en self?
Dis baie goed, man.
Ag nee, dan is ek bly om te hoor. No, and Chairperson, I can just say it's good to see our colleagues from Labour. We spent so many hours together. It's good to see them. Chairperson, maybe from my side, I have one question and then I have comments. And I would like to, as it maybe agree with or second my colleagues in terms of the worrying factor, and I think the high-level panel report just confirms what we actually saw on the ground in terms of the oversight, is that there is no political will. We have departments that are not completely exercising their mandates. They aren't getting to the ground. The amount of times us as a portfolio committee got lost on oversight because the officials who were supposed to know where we are going and did not know where we are going is reinforced by this panel. So I would like to, by this report, so I would like to welcome the report from Ms. Claessens and the team. I think it's 700 pages. So I wish to as well, and maybe to reiterate what Honorable Masipa said is, and Chairperson, I think it is a good suggestion from yourself, and I would like to second that we get a program going forward, and that we actually this time stick to it. I know there was other things in terms of in terms of parliamentary programs that ensured that our program chopped and changed a lot, but that would be good to have timeframes to actually see us attend this. It's been 2 years overdue, this our work as a committee, and we need to see that. So I would like to second that. Chairperson, in terms of the training, I think it is a good idea, and it is worrying from my side to see that and to hear that we have courts and we have judges that aren't up to date with the latest ESTA and LTA legislation. I think we saw that on the ground, and I think us as a portfolio committee, Chairperson, and I would like to maybe leave a suggestion here, because I don't necessarily think it falls under this portfolio's work, but maybe, or this joint committee's work, but maybe as under ours as a portfolio committee, is we need to speak about funding for ESTA. We continually saw it. We spoke with provincial departments as well, where it is a concurrent function, where we've gathered frustrations in terms of the process, in terms of the court dealings with ESTA, in terms of funding for ESTA, in terms of the concurrence, the essence of what is the problem. And I think we need to speak on that. Chairperson, I would like to know And then maybe you would stop me if it is out of order. Mrs. Anika said that she thinks that us as a parliament aren't completely using our oversight role as fully as we should, that we are limiting ourselves there too. And I would like to find out from her, if she has the answers, how would this animal look? How would we as a department, as a portfolio committee, be better at oversight? How would they like to see us improve? I think us as a committee, I myself am frustrated with the process. I'm frustrated with the process of oversight. We continually during our oversight said as well, we come here and we've seen it from multiple stakeholders that said, 5 years ago, we saw human settlement here. They made promises and we've never seen them again. Now you are here, you are making promises that the land will at last be transferred to us, and this will only be empty promises. So I would really like to gain for a committee to increase. And then chairperson, and then I think further, I think it would be very, very important for us as a portfolio committee, as Mrs. Anika said, that the presidential panel and the high-level panel were to a large extent had the same findings, and I think we as a committee had the same findings. I think the goal would be then be looking at the end product to take all of these different works, all of these different reports that we have received and that people have done work, have a collaboration and set one thing up the table, have resolutions, and then go forward. Because I don't think in terms of the rights of farm workers and farm dwellers, in terms of ESTA legislation, I don't think we are going to move ahead if we do this silo operation. Chairperson, but I've spoken too long. I will leave it at that.
Thank you, Akbar Briat. Tobela Memasho.
Good morning, Chairperson.
Le kae ma'am.
Papa re tsuile ra lena.
Re tsuile le rena o na letho.
Thank you. Khoshiaka, and all members of the portfolio committees, both portfolio committees and officials. Let me take this opportunity, Chairperson, to appreciate the presented high-level panel report to us. To this sitting of the Joint Standing Committee. I would like to join my colleagues, Mehlape and Ntatuma Sipa, on the issue of monitoring and evaluation on the side of the executive. Chairperson, indeed, there is a gap between us and the executive on this matter. It has been an evidence on what we have seen out there when we were doing our oversight. Which it was shocking to me because I've never seen what I saw. I'm still having pain in my heart, Chairperson, which makes me not to sleep. I don't know as to whether I will recover because, you know, the age is coming in, and with this big problem that I saw on my people in my country, I feel very, 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 very offended. One will say that there is a need to intensify our oversight to the executive on this matter as a matter of urgency. Our communities are suffering out there. Farm owners are still doing as they wish to those communities, which we don't think is fair to the people of this country. We understand that people bought the land. We understand that people work the land. The land is fertile for them. But the farm owners must also realize and think, a Chairperson, that they came to South Africa, they found the land with us, and they take the land from us, but they must think for our people. There is no way that we can just say, because they bought the land, people must suffer the way we saw people suffering. Our own people must be killed as we saw them being killed, and the police are doing nothing. It's for the executive, it's for those that are given the authorities to make sure that they look into their programs and make sure that they do oversight on their departments, because they're the implementers of our laws. We are not implementers, we are lawmakers. We can only do oversight. It's the executive that must tell us What is it that they're doing about these problems that we see out there? I think there is a need for the Joint Standing Committee to put in time frames which will allow us to get reports on this matter, the real reports, not fake reports, real reports. The officials of both departments should help us in making sure that the past legislation and laws are implemented. Yes, Chairperson, when we were out there, we could realize that some of the provinces, they didn't even know what ESTA looked like. They tell you that they've got only 2 months knowing about ESTA. We need indeed to intensify that training to the courts, to the magistrates, to the police, and our community awareness campaign must be done as a matter of agency, Chairperson. I thank you.
Thank you, Honorable Memasho. See the hand of Honorable Yana is still on. Do you have another question? Honorable Inana Memasho, can you also lower your hand?
No, I don't have. It's an old hand.
All right, thank you, Honorable Inana. Honorable members, is there any other honorable member who may wish to pose the question and has not had a chance?
Yes, Honorable Chair.
Yes, Honorable Ntate Matias, please proceed.
Thanks so much, and greetings to all and to Professor Klassen. Well, look,
it's Dr. Klassen.
Honorable Dr. Klassen. Okay. Now, look, my Honorable Chair. Presentations such as this, Honorable Chair, and the reality on the ground really reveals the truth of that all what we are doing is just for academic purposes. Academic purposes just to make us much clever about what we're doing, but with no real impact on the ground, on the lives of the people. So members spoke and I agree with them that what we are doing is intellectual exercise of elites who are engaged in an intellectual academic exercise. Until we know that agrarian relations on the farms, for as long as they remain the way they are, as long as they remain as they are. Honorable Chair, am I still there? My internet is not strong.
Yeah, it's internet, Honorable Matthias. We're trying our level best to hear what you are saying, but please proceed.
Yeah, I'm saying for as long as agrarian relations on the farms they remain as they are, as long as the patterns of land ownership are as they are, as members have said, we will talk and talk and talk until we turn blue on our faces. There's nothing concretely that's going to emerge out of this exercise. No matter how much we may want to amend existing legislation, no matter how much we may want to align the existing legislation to address what the high-level panel has observed and is recommending, no matter how much we may try to reconfigure the oversight functions and role of Parliament, no matter how biting the legislature can be, no matter how strict measures that Parliament can devise to hold the executive accountable, we may make Honorable Mandla Madiba Mandela the president tomorrow, or even Honorable the Commander-in-Chief Julius Malema, the president of the Republic tomorrow. For as long as agrarian relations and the patterns of land ownership remain what they are on the ground, as we're going to make, will still be dealing with these matters with no solution on site. Dr. Klassen recommends what he calls new legislation on land rights records. You can record these rights of farm workers, farm dwellers, and labor tenants. You will be recording them against what? Against an established jurisprudence that protects private land rights of people, of those who own land today. And that will come to zero because the established jurisprudence is biased towards the landlords, and it would serve no purpose whatsoever for the poor farm workers, farm dwellers, and labor tenants. So we need a radical change on agrarian relations on farms, on the patterns of land ownership, for us to get at least to a point where we say the ESTA legislation, the Land Tenure Act, and other related legislations can sometime, not in a distant future, make sense to farm dwellers, farm workers, and labor tenants. Oh, other than that, Honorable Chair, perhaps Dr. Klassen must tell us, what is it that we need to do, which will not in a superficial, in a cosmetic way, because that's what we're trying to do here, to cosmetically close over of these hard realities on the ground with no decisive intervention to see to it that farm workers, farm dwellers, and labor tenants, their rights are secured and protected, and they can claim land rights and land ownership on farms that they find themselves scattered all over the place with no recourse in law to mediate in their name in instances of evictions. Perhaps she must tell us what else that can be done other than to superficially and cosmetically close over these realities. Thank you so much, Honorable Chair.
Thank you, Honorable Ntate Matiase. Honorable members.
Honorable Chair.
Yes, Honorable Kabe.
Maybe just one question that is bothering me, that the doctor can help me with, Dr. Klassen. If a farm dweller or farm dwellers wake up and they are evicted, or they wake up and the owner, the employer has sold the farm and they don't have anywhere to go, where could they go to report their matter? Who's responsible? Is it labor? Is it agriculture? Is it police? Who's responsible for such cases? Because it's like it's a hot potato. Nobody knows what to do with them. You will find them instead better way reported by public when they are sitting next to the roadside. Who's responsible for such cases?
Thank you, Honorable Kabe, for a precise and direct question. Honorable members, perhaps let me also clarify that this agenda was part of our initial program that was adopted by the joint portfolio committees sittings. But due to the challenges in the parliamentary program, we ended up with having to postpone the oversight, of which it was postponed, and including the departmental briefings, which are now scheduled for the 9th and the 16th of September. As I said, from now on, we will be having our joint sitting, joint portfolio committee sittings on the Fridays. And let me also take this opportunity, therefore, to welcome the presentation and pose the questions of clarity on my side as well to the high-level panel presentation by Dr. Klassen. In the report presented before the Portfolio Committee, there is a finding that there is a total systems failure, which contributes significantly to the weakening of secure tenure for farm dwellers. May you please explain what you mean by total systems failure, if you can clarify that, Dr. Klassen, as well as further, what would a system redesign entail if we had to look at the corrective measures? How would we go about in redesigning the system? Second question is, during our oversight visit, we heard of the notions of private property being used to deny farm dwellers and labor tenants access to services such as access to clean drinkable water, as well as access to electricity, but also access to use of public roads, which farmers deliberately fenced in an access road to a certain area of where the tenants were living. What is your view around this? Most farm dwellers do not believe that the portions where they live should be regarded as private property of the farm owner, particularly their family graves, which farm owners have always regarded as being private property. Thirdly, there are intentions arising from redistribution of land where there are labor tenants. In their view, labor tenants believe that they are undermined by the LTA, which is not prioritized. In your high-level panel work, what was your observation? Is there any law in place that should be done to ensure that labor tenants' applications are given full respect, just as restitution and redistribution is a redistribution application? And on question 4, there has been calls for expropriation of land of abusive farmers for the benefit of farm dwellers. The high-level panel report has addressed the question of expropriation as a mechanism to speed up land redistribution, including the redistribution for securing tenure rights of farm dwellers. Did the high-level panel report make a finding about factors that makes it difficult to expropriate land, including the idea of expropriation without compensation? Lastly, honorable members, the question about the role of Parliament and its weaknesses is a matter that needs further discussion. In your view, Dr. Klassen, what do you think Parliament could have done to ensure that the matters that the courts have ordered on, for example, the Lamosa and Melase judgment, would have been avoided? That is all on our side. We'll now revert back to the presenter, Dr. Klassen, for responses. You may proceed.
Well, just to say thank you very much, and that this session has really re-inspired me. I must say that when the committee secretariat asked me to do this presentation, I was pretty despairing, and I kind of thought, Parliament has done nothing about the high-level panel report. What's the point of going over its findings yet again? But I've got great courage, Subindi, from all the things that the members of Parliament have said after their oversight visit. And so I'm going to go back really to try and answer these questions with the kind of positive outlook that the panel, including former President Motlanthe, brought to this work, where we did see real ways of addressing some of these intractable problems. I want to start at the beginning, and I'm going to go very fast because I know people mentioned that some of you have to leave, but also because I know that Ruth Hall is waiting to present, and so I'm unashamedly going to bat some of the answers to her. But just to say, to start with the ZZ2, we heard exactly the same rumors at the public hearings, but I don't know anything more than those rumors about collusion with them. And then the next question was, who should provide the training? So I think that this question of training is really important. And I wonder if Parliament couldn't actually approach the Legal Aid Board to design training, but also the Justice College, because to train magistrates and judicial officers is quite complicated because, you know, they're independent, but there is a Justice College, and they can develop a curriculum in which they update all the judgments, the implications of those judgments, and they regularly do provide training for magistrates and judicial officers. So my recommendation is that there are bodies placed to do the training that are much better placed to do the training than the department, and that if you kick this back to the department, I don't think you'd get anywhere. Whereas if Parliament talked about a partnership with the Legal Aid Board or with the Justice College or even with the Human Rights Commission, and you have a parliamentary mandated training processes, I think that could breathe new life into this lack of information that is used as an excuse for allowing these evictions to continue. And then the question or the issue raised by Ndabe about the APP system, and that this doesn't talk to the reality of what's happening on the ground and how to deal with better oversight. I think Ruth will talk about that, but in my view, and I think this was discussed in the high-level panel, Parliament needs to set the criteria that it wants the departments to report on. It's not for the departments to set the criteria for how they will report to you. And I think that if you could say, we want reports on exactly these Section 4 subsidies, how many have been spent, how many have not been spent, you know, how many are there? We want reports from the police. And I think, you know, you need to speak to your counterparts in other parts of Parliament about getting reports from the police. But I think it's for you to design what information you need in order to exercise proper oversight, for you to design that, and then for you to demand that, and then to look at what remedies there are when those bodies refuse to provide that information. And maybe those have to be to do with their budget allocations, which is in Parliament's power. But I really do think that until you get serious about identifying where the gaps are and what the reports need to contain, and you leave that structuring in the hands of the departments, you're never going to get the information you need to be able to exercise oversight. And then, yes, this question of training of the South African police services, and that other question about who do farm workers go to? Who is responsible? Actually, their first port of call is the police, because these acts make it a criminal offense to evict people. And also this process of constructive eviction is also breaking the law. And so the police need to know that these are crimes committed by the farmers, and we need to see some arrests of farmers for breaking the law. So obviously, then the departments have to come in with the resources for the on-farm and off-farm settlements, and with mediation, and there are all these other kinds of roles. But I appreciate that some of these areas are very, very isolated and they don't have cell phone coverage, but the police is more accessible than most other institutions. And that is where a fundamental problem arises. And I don't know if this committee's got to speak to its counterpart who's responsible for the police. And then oversight, how do we do this better? I've tried to answer that, but I think Professor Hall has got ideas of the kinds of standards and requirements that you could set in respect of the different actors, not just the Department of Rural Development, also the Department of Labor, also the police, that they must report to you in relation to. Then there was the question about the conflict. Let me just see if I've, yes. On the question of the total system failure, that was a term adopted by the department itself. And in fact, I've seen that Ruth has written about what would be required to deal with total system failure. So I'm going to ask Ruth to answer that one. On this question of private property, I feel very passionate about that because it is in fact a myth that private property gives you absolute ownership, that people do have rights of way. They do have established beneficial rights, and our law has always recognized those countervailing rights. But the way that property is taught in the law schools continues to elevate title, private property, as a system of exclusive ownership. Yet we have had eminent legal historians and professors showing that in reality, you have coexisting rights on property, and that title does not give you the right to override other rights, rights to the environment, rights of way, rights of occupation and use. It doesn't give the owner the right to simply evict tenants. There's bodies of law to deal with rent control. And the ESTA and the Labour Tenants Act were laws that actually took aspects of the owner's control and vested those in the occupiers. But because we have this obsession with private title as the only form of ownership that we respect, we assume that private owners can use that ownership to trump other people's rights on the land. In law, they can't. And that has to be one of the key elements of the training, to explain to the police that the fact that a farmer has the title deed does not give him the legal right to cut off somebody's water, does not give him the legal right to evict that person, that people have statutory rights, countervailing statutory rights that limit the farmer's ownership powers. And this is something which has become ideological in South Africa, where we just see private property as a blanket of power that blankets the owner and completely is ripped away from the shivering other people who in fact have rights in law that limit the owner's rights. But maybe we can talk about that another time, because I feel passionate about that. I know as well that Ruth is going to talk about this question of constructive eviction and the way in which owners chip away at people's other rights to housing and water in order to evict them. This question between redistribution and labor tenancy, the panel found that actually you've got to prioritize the property rights of the people on the land, which is the labor tenants. They have property rights. And again, I think this is something that does require more discussion, and maybe these laws need to be made more explicit. But, you know, we recently had the very important Constitutional Court judgment in the Maledu case, where the rights of customary owners were upheld when a mining company said, our mining right trumps their right. And the court said, no, we have a right to tenure security. We have a recognition of informal land rights, and those rights cannot be trumped by mining. So this is a key part of our law that we are developing to protect informal land rights or coexisting land rights. That's why we've got such a resounding judgment in the Mwelase case, because government acted as though the labor tenants had no property rights, whereas the Labor Tenant Act gives them property rights, and it's for government to catch up and give them some recorded recognition of those rights. It cannot deny that their form of rights is also a form of property rights. And then the panel did recommend that expropriation should be used much more freely. We actually had a round table on the question of expropriation without compensation. We were addressed by Judge Dikgang Moseneke, and we were addressed by Tembeka Ncukai-Tobi, and in that same round table by church leaders. And what we found is that the Constitution already provides that people can expropriate without compensation in certain instances, particularly where they have countervailing land rights, like labor tenants do. So yes, I think that has brought me to the end of the questions. I'm sorry that I rushed through. I'm extremely heartened by the input of members of parliament, and I wish you incredible good luck and power in exercising your oversight. I think, to come back to one that I missed by mistake, I think that if you had asked the right questions of the Department of Rural Development and demanded that they account in respect of their stated refusal to honor the rights of labor tenants, you could have averted that resounding judgment. I must say, though, that I absolutely commend this committee for the ways in which it has tried to handle the Ingonyama Trust issue and its tenacity in drawing attention to the abrogation of rights there. And in a way, I think that its strong insistence on respect for the basic rights of the people living on that land did help in securing that judgment, which unfortunately is suspended because the main part of the case has been appealed, and we're still awaiting the judgment of the Supreme Court of Appeal. Sorry for rushing, but I know you're short of time.
No, thank you, Dr. Klassen, for your input. We are totally enriched and empowered from our engagement with you today. And I think a lot of honorable members have a couple of notes to take away. But for us, it remains crucial, honorable members. So as Honorable Matthias says, we do not fall into cosmetic kind of challenges with legislation. We actually come up with meaningful impact on the daily lives of farm workers and farm dwellers and labor tenants. We therefore have been continuously looking at how do we find solutions, particularly for farm workers that find themselves under brutal atrocities meted out against them on a daily basis, where farm owners, on the pretext of private property, totally cut out access to clean drinkable water, electricity to farm dwellers, and also deny them access to their own family graves. In some instances, we found that they've just eliminated 30 graves and started plowing over those remains, which is totally unacceptable. And we would need to find ways of ensuring that our people are protected. Where some of the challenges come is from the law enforcers themselves, who seem to be more favorable to farm owners. In Mpumalanga, we were told that the farm owner shot one of his employees in the eye in the presence of 2 policemen, and nothing was ever done. There is no case to date that has ever followed on to that. From there, the following day, he went and killed 2 brothers. And to date, there's been no case opened or even an investigation carried out. So this requires us to really take action. But I would do injustice to our committee if I don't speak to Ingonyama Trust. From the onset, when we embarked on this 6th Parliament, ours was to say to the department, if Ingonyama Trust has been exemplary for the past political dispensation, we have to be able to take it over to other kingdoms, as South Africa is not only sitting with one monarch and that of the Zulu kingdom, but there's many other equally important monarchs, such as the Balobedu of Queen Mjaji, the Bapedi of Skukune, the vendors of Rabulana, the Xhosas of King Sigcawu, the late Zwelonke, also the Mpondos of King Sigcawu, the late King Zanozuko, who we can be able to have this rolled out to. And if the department is confident that Ingonyama Trust is the right model, then we should be expanding that to the other kingdoms. But if we find faults and we find it to not be serving the interests of the vast majority of our people, then we should immediately rescind it. And I think it is high time, honorable members, we look in depth into the current rulings and the judgment on Ingonyama Trust and effect the changes that we want as legislators. We therefore want to thank Dr. Anika Klassen for her input in this morning's sessions. Let me also take the opportunity, honorable members, to welcome Professor Ruth Hall, who has now joined us for this session earlier on. She will be presenting on the Presidential Advisory Panel report to the portfolio committees of employment and labor, as well as agriculture, land reform, and rural development. You are welcome, Professor Hall, and you may please proceed. I will now take the opportunity to hand over to Honorable Chape to proceed with the rest of the session, as I'm going to be heading for prayers, going to mosque at 12 o'clock. Thank you, and good luck with the rest of the proceedings. Dr. Hall, you may proceed. Professor Hall. You are muted. You are muted, Professor Hall.
Many thanks, Chair. I'm really pleased and honored to be with you all today. And I'd like to share, also echoing the sense that I'm just encouraged that this conversation is taking the sense of the tone of urgency that I've heard in the past little while. I would like to share with you a presentation that will cover both the findings and recommendations of the presidential panel on land reform, but also some other resources and news about what else has been happening in the past few years since these 2 important panels have reported. So I will proceed with briefly some context, talk about the Presidential Advisory Panel, what government has done since, as far as we know, what farm workers and their organizations have tried to do since, I want to particularly mention a national conference on the future of farm workers that farm worker organizations themselves organized and which the Minister of Labour attended. And then also to provide some broader and more updated context on minimum wages, the impacts of COVID on food prices and hunger affecting farm workers. And finally, just before options for the way forward, I thought it'd be useful to reflect on an overall timeline of what has been done, all the processes in government, by the department, all the summits, all of these processes that have, in many respects, reiterated the same points about the failures to address the crisis of tenure, labor rights and livelihoods for farm workers and dwellers over the past 25 years. So I'm going to share a bit of a timeline. So I think that I probably don't need to go past this as a background, but clearly parts of the country, farm workers are like wage workers. In many parts of the country, farm workers are small-scale farmers in their own right. And there's a huge spectrum of contexts that one needs to be aware of. And I'm sure that you saw this very vividly on your oversight visit, that farms are a particular place where people's homes are defined by others as a place of business. But in fact, these are sites of building of social relations. But what this does is, unlike other sectors of society, it gives enormous power to the owners of private land to control a huge spectrum of areas of life, of private life, of people who live on farms. And yet, farm workers and dwellers around the country try to establish their own kinds of livelihoods beyond wage work. There are local economies within farms that we need to be aware of. There are also, there's a lot of resistance on farms to attempts by farm owners to control who may live there. So we found in research around the country, including here in Limpopo, big disputes about who may be on farms, whether farm dwellers can invite family members to stay with them, who is a squatter, who is a trespasser, who is a visitor, is often clear and disputed. This particularly has a gendered dimension, with women having to be attached to men in order to retain access to homes on farm. There was an important land claims court judgment some years ago, the Claassen judgment, which clarified that women have independent tenure rights and a woman's tenure rights cannot be extinguished on the extinguishment of a male partner's employment or tenure. So this idea of unfettered control over the area of a farm remarkably is still in place, not only in the views of farmers, but as we've heard already, and I will reiterate, in the views of officials who seem to regard the boundaries of a farm as sacrosanct and somehow outside of the sphere of jurisdiction of the state, which is a critical area where more politically committed progress is needed. I also want to emphasize that the kinds of forms of control on farms often include overstretch in terms of private owners' attempts to take on state-like functions, including securitizing access to farms and forms of punishment inside farms. So there are blurred lines between security to protect the farm and its residents from outsiders and forms of internal discipline. And I think that that has been documented. So these are issues that extend far beyond only the question of evictions. More broadly, one of the social crises affecting families living on farms is the question of children's access to education and the crisis caused by the closure of farm schools and the absence of adequate rural transport. One of the most important provisions of ESTA and the strongest provisions of ESTA is the provision for long-term security of tenure. This is section 8.4, that elderly people who are over 60 and have resided on the farm for more than 10 years should have permanent and unconditional tenure on land. In other words, that they cannot be evicted other than through a significant violation of the terms of their occupation. And yet we find that this is happening. And most disturbingly, for instance, a case, the Joostenburg case outside Robertson, Ashton in the Western Cape just a few years ago, where attorneys appointed by the Land Rights Management Facility did not raise this provision, and the Magistrates Court itself approved an eviction of long-term occupiers in violation of the law. So the Magistrates Courts continue to pass down judgments that actually are a misapplication of the law, fail to uphold the rights in it, and even the lawyers contracted by the department failed to understand these elements of the law. I want to emphasize, and this is very important when we think about the relationship between farm worker and dweller rights and expropriation without compensation or speeding up land reform, that more land reform in general is not going to help farm workers and dwellers specifically, unless they are the targets of it and unless their existing tenure rights form the basis for the land reform. Across the country where land has been restored to claimants, we find situations where the claimants, who are often the people who were forcibly removed in the past, come back as owners, but those who managed to retain access to the land then become the tenants of those claimants, creating enormous complications. Often the old farm workers are subject to losing jobs and sometimes being evicted by the new owners, but in many cases coexist. So the question about recognizing that occupation of farms constitutes tenure applies whether or not it's an individual white farm owner, a big company, or a CPA. Across the board, there needs to be recognition that there are these rights. Now, I know that, and I'm not sure if any of you were in the committee in 2005 or if you were in Parliament when this was presented, but the only national eviction survey that has been conducted in the post-apartheid era up to 2004 reported in 2005 these figures. And here I need to pause and check, has this already been discussed? I'm sorry, during the previous presentation. If I'm repeating, I apologize, please interrupt me.
No, it wasn't presented.
Okay. Okay, so what this points to, and I'll try and indicate, so this was a major national study that had a reference group that included the department and included also trade unions and Agri South Africa. So this was a national representative sample survey that looked at people who had been moved off farms or had been moved off farms under conditions that constitute eviction. And what was found, and this being conducted in 2004, is that more than 2.3 million people had, since in those first 10 years of democracy, moved off farms for some reason. And of those, nearly 1,942,000 had done so under conditions of forced eviction. Less than 1% of those had gone through a legal process, and yet Esther had been in place for most of that period. And what's remarkable about this is not just the scale of this forced movement of people, but that also the forced movement of Black people off farms accelerated after 1994. So it didn't slow down. So the period of forced removals under apartheid actually accelerated in the democratic era. We know that actually the evictions are not at the same rate now, partly just because there are fewer people left on farms. So if we I thought it would be useful to clarify, sorry about that mistake in the middle, that if we think about these two categories of farm workers and farm dwellers, historically, most farm workers are people who previously occupied and used and were the de facto owners of land, either in that place or elsewhere. And farm workers, those who were employed, was a small subset of that. And with all the interventions against sharecropping, labor tenancy, and forcing people who live on farms to supply their labor or to leave, we see this farm dweller community shrinking and the proportion of farm workers expanding, right? And over time, what we also see is that more and more farm workers are off farm in informal settlements, selling their labor onto farms. So these two categories are becoming more distinct. And of course, the number of farm dwellers who are not employed is shrinking particularly fast. So ultimately, we may be in a situation where farmers are pushing out the last farm dwellers who are not providing labor and keeping a very small core, this overlap in the middle, a very small core of farm workers on farm, typically the higher paid, more skilled workers on farm, and relying basically on labor brokers to provide off-farm work on a more seasonal basis, depending on the sector. But what this does is it actually externalizes all the costs and means that as a result of these evictions, municipalities are faced with large numbers of farm workers who've been evicted and for whom there's no plan in IDPs. So municipalities are not planning for farm dwellers on farms, but nor are they planning for the farm dwellers who are evicted from farms. And all of this raises questions of really what is the future? A massively shrinking farm dweller population that is not employed and a small core of on-farm farm workers with a sustained off-farm. So this is the condition in which, even if we were to stem the tide of illegal evictions, which is not happening, an alternative has to be conceived in which farm workers and dwellers have opportunities for livelihoods and access to land on their own terms. So it's in this context and against the background of many crises and changes that are pushing change. It's not just about the law and whether farmers are violating it, whether the state is enforcing. There are wider changes that are also acting in the sector, including climate change, economic restructuring, changes in input prices. Farmers squeeze labor costs and seek to externalize. We see the conversion to game farming, which has had a devastating effect on farm workers. Horticultural intensification in some areas has somewhat offset that. Restitution in some provinces, like Limpopo and Mpumalanga, with pretty much wall-to-wall claims in some districts, that basically the future of farm workers and dwellers needs to be dealt with centrally through rethinking how restitution happens, rather than continuing on this case-by-case basis, which has generally ignored the interests and conditions of farm workers and dwellers. And then also the context of migration, both transnational, but particularly internal within the country, as people move across the country in seek of livelihoods. So I think that that's just as background to shifting context historically, but clearly the crisis of tenure on farms is much more than just the question of whether you're able to stay or whether you're evicted. And what we have picked up and would want to emphasize that losing a home on a farm is much more than losing a home. It's a whole lot of means of livelihood that is lost. For instance, the contrast between the kinds of homesteads that people sometimes may have on a farm, or access to resources, firewood, ability to graze cattle, and the sort of resettlement camp kind of look of people who are forced either onto the edge of small towns or into communal areas after eviction. So I want to emphasize then some of the key parameters of the advisory panel. The Presidential Advisory Panel appointed in September 2018 and a final report to Parliament in July 2019. And of course, this had a different mandate from the high-level panel. The presidential panel was initiated in response to the debate on expropriation without compensation, but in fact, its mandate was to provide a unified policy perspective on land reform as a whole under the Constitution, and to review applicable legislation in terms of all three pillars of land reform. With respect to EWC, the panel had to consider the circumstances in which it should happen, procedures, institutions, and the rights of people, and to provide a broader diagnosis of the problems and limitations of laws, policies, and implementation. So in brief, we conducted, insofar as we could, within constraints, engagements both with relevant state institutions, various departments, the Commission, Office of the Valuer General, roundtables with rural dwellers, with open dwellers, and 2 national colloquia. And I'll also mention that there were areas of disagreement. And so somewhat unlike the high-level panel, there was disagreement within our panel, largely because of the presence of representatives of commercial farming. Another key difference is that the extent of public input, particularly by the people affected themselves, was far greater in the high-level panel than in our panel. So to a large degree, our panel reiterated and reinforced some of the key messages from the high-level panel. We did not have as broadly inclusive and participatory input into our panel's deliberations as the high-level panel had. That said, some of the key problem statements probably are not surprising to you. The start of our report, I just want to flag some of our recommendations. They are summarized quite neatly in the final section of the report if you wish to refer to it, but I just want to summarize that our answer was not just about implementing existing law or implementing existing policy, but the need actually for a broader rethink of what land reform is for, who it's for, and what it should achieve, and link this to a wider view of agrarian reform. In other words, not just about land rights within the existing structure of the economy, but a shift that would change the types, scales, and forms of land use. So subdivision, promotion of small-scale farmers, rather than simply either a deracialization of the existing unequal structure or just protecting those who are on farms. And importantly, and this was a point made in the high-level panel, I think it was the first time it has been proposed, that there should be legislation on Section 25.5. So the right of access to land on an equitable basis, which every citizen has, doesn't have framework legislation under a democratic order. We still rely on a 1993 law that empowers the minister to give out land or subsidies, but we don't have a bill that says, what is this right of access to land on an equitable basis? So I think it's important that when thinking about farm dwellers, they don't only have a right to defend the tenure that they have a right to gain access to land on an equitable basis, to have a fair opportunity to get access to the land that they want and need for their livelihoods. And we don't have a mechanism for that. And related to that is also the proposal for a land rights protector, something like a Chapter 9 kind of institution, like a public protector that has broad oversight roles and acts as an independent body. And I think perhaps we can discuss that a little further later. So these 2 broad areas in which actually our policy doesn't know where it's going. A white paper and a vision for agrarian reform are the first, and then the 2 specific proposals around a national land reform framework bill to say, what is this right of equitable access to land? And secondly, a land rights protector. We did address expropriation without compensation. By itself, that is not necessarily to the benefit of farm dwellers, but this issue about land donations was a source of contention in the committee. Firstly, there's nothing wrong with donation, but by itself, it's not an answer to any of the challenges faced. So it's worrying to see in the latest agricultural master plan that land donation is actually prioritized over negotiated acquisition or expropriation. It actually suggests that the state is abrogating its obligations and asking private property owners to take charge of the land reform process, which is an approach doomed to fail in my view. The core recommendations around the issues of farm workers and farm dwellers was, well, firstly, to recognize that we have a legal framework. It has not been implemented. So the first one is to end farm evictions and illegal farm evictions, which most evictions are, and to urgently expedite mechanisms to secure farm dwellers' tenure rights within the law. And we can talk about several forms of that. Importantly, to create an application system for farm dwellers to upgrade their tenure. So if people have a right to long-term secure tenure, including private ownership or other forms of secure long-term rights, how do they access this? It is still not clear how to use Section 4 of ESTA, and yet the wording of the legislation is very prescriptive. It says the minister shall, not the minister may, enable people to do this. So Section 4 is a major missed opportunity, and it's in a sense it is the transformatory component of ESTA. ESTA is not only about defending what people have, the little that people have. Section 4 says defending the tenure rights of farm dwellers is really wholly inadequate, given how limited they are. So Section 4 is a priority. Municipalities must include proposals for on-site settlement options for farm dwellers, including when there is a threatened eviction. The answer to a threatened eviction is not simply to facilitate that process through the courts, but to propose alternatives to accommodation, such as a new settlement plan, expropriation of a farm or a subdivision, a subdivided portion to provide for an alternative. So the idea that the state is sitting back and allowing this to happen needs to shift. There needs to be a review of the farm schools policy, because the ability of families to make a livelihood and to stay together in rural areas depends on being able to educate their children. And the reforms to farm schools have created long-term crises with that. The idea that we have a law that is actually not only unenforced, but in a sense unenforceable, is really, that is part of what you asked about, I think, Chair, earlier. What is total system breakdown? It's when you have a law that says this must happen, and a violation of this provision is a criminal act. And yet, our South African police services for years has not had a code with which to charge somebody with a violation of that law. So if the law is being broken, as we saw from the statistics, on a routine basis, and yet when people come to the police and say, I have been forcibly evicted, they say it's the farmer's land. So it's not just a matter of awareness or will, it's actually the systems have not been set in place to provide for prosecution and conviction for violations of Section 23 of ESTA. I must say that this is something that Minister Lamola has taken up, and I think it would be worth getting a response both from Minister Lamola and the Police Commissioner, to whom he wrote a memo following our panel. The sixth major area, and I hear that you've discussed this, is the urgent issue of providing training to police, prosecutors, magistrates, and attorneys. At the time, it was the Land Rights Management Facility. It is encouraging that the Legal Aid Board is now addressing the issue of farm dwellers. And I think that a collaboration with your committees and the Legal Aid Board around such training, and I must say universities, our own, our law faculties, other law faculties around the country have continuously, and specialist human rights legal firms have offered to engage and to collaboratively design and facilitate training. So what's needed actually is specialist capacity to provide systematic training, which was done actually in the 1990s and then stopped in the early 2000s. Another initiative to implement these laws that was initiated in the 90s and also stopped in the early 2000s was the system of having cooperative and coordinated oversight of implementation by different spheres of government. So what the Department of Land Affairs established in the 90s was an ESTA task team in the provinces, where their office in each province would convene a meeting with the Premier's office, with police, with labor, with agriculture, and also include, where appropriate, non-governmental organizations, rural advice officers, lawyers and others, to provide regular oversight. What are the trends? What's happening? What interventions are possible? And then also, importantly, to connect with local government. So this was a model that was not perfect, but it was abandoned, and it was the best we had. And our panel proposed that both to monitor and to coordinate and to popularize the law through all an intergovernmental collaboration. An ESTA task team system is essential, both at a national level, but also in the provinces. Around labor tenants, clearly labor tenants are the people who are already on the land. They're already working the land. They are the people who, despite all the laws over time, have managed to not be entirely dispossessed. And the Labor Tenants Act is like restitution for the people whose hold on land has not yet entirely been lost. And well, I'm sure that you have discussed the Labor Tenant Act at in some depth, so I won't go through this, but it's clear from the Molase case, it's clear from the high-level panel, the database system and the losing of claims has been a failure. There's the need for the plan. Parliament should be monitoring this plan. I'm not sure how you're doing that, or perhaps we can talk about how you can monitor, what kinds of questions to ask, but also to address the issue of overlapping labor tenant and restitution claims so that conflicts are not created between those who managed to keep a hold on land and those that didn't when they address their restitution claims. And there's absolutely must be a right for people who previously claimed to resubmit claims. Importantly, and this is something that perhaps you could consider, is if there is a single context in which expropriation with no compensation or with minimal compensation could be justified, it is surely where private owners don't have effective occupation and use of a portion of a farm or of a whole farm, where labor tenants have those tenure rights. And if we think of tenure as being not just something that you have or don't have, but a spectrum of rights, farm owners don't have rights to those portions of land, and should they be compensated when that is acquired in order to settle labor tenant claims? And that is precisely the argument that was used. That was part of the argument that was used in the Msiza case when Advocate Tembeka Nqukatobi, acting in the Land Claims Court, said we do not need to pay market price. And it's very unfortunate that that was overturned at the Supreme Court of Appeal and was never referred on to the Constitutional Court. It would have been the first judgment to test the question of just and equitable compensation. So we missed that opportunity, both to push and clarify just and equitable compensation, but also importantly to prioritize labor tenants. I will also just mention briefly that across the board, our panel emphasized that actually speeding up land reform, trying to root out corruption or abuse is actually not going to shift anything unless we really recognize tenure reform as being at the heart of land reform, that actually we cannot just have redistribution of individual parcels of land to the lucky few and leave the hierarchy and inequalities between owners and occupiers, owners and tenants, unchanged. And so around tenure reform, the priority issue was about creating a mechanism for legally enforceable rights across all tenure regimes, including privately owned farms. So what is the form of documented and enforceable rights that farm dwellers could have? So in this respect, our panel recommended a land records bill, a bill that unifies the country that has been so divided by different forms of tenure, and says that actually we all have entitlement to register rights, even if the content of our rights differ. The rights of people who are not private owners have to be visible and recorded and defensible. And this should include, crucially, farm dwellers alongside people who live in other forms of informal tenure. Otherwise, we retain this privileging of private title. So the proposals were, let's initiate widespread consultations around a land records bill and have a working group and engage with Parliament around it. As far as I'm aware, that process has not been started. And very sadly, one of the great champions of this proposal was Dr. Vuyo Maklati, who chaired our panel, who tragically passed away 2 years ago. The process should draw on experiments and pilots that have already been done in parts of South Africa, elsewhere in the region, including not just extending the existing deeds registry system to other tenure forms, but also using other types of technology. But we will need to think about other forms of recording diverse types of land rights. And I think that that's crucial for farm dwellers too. And we also emphasized the need for some institutional reforms. I'm not going to go through those. I do want to mention, although I don't want to get into it, that one of our panel members actually insisted on identifying areas of disagreement. So this presentation would be incomplete without mentioning that there were objections on essentially most of the recommendations. So that is the end of the presentation from the advisory panel. With your permission, Chair, I would like to just summarize what, in our understanding, has happened in the past few years, the past 3 years, since the last of these panels. So there's been 5 years since the high-level panel, 3 years since the presidential advisory panel. What has happened? There was the ESTA Amendment of 2018, addressing some problems, but also, importantly, it replaced the idea of subsidies under Section 4 with tenure grants. And the significance of this is actually quite worrying, in that tenure grants could now be made available to farmers, to the landowners. So the idea of subsidies for people to upgrade the tenure rights has now been diluted and expanded to tenure grants that could be made available to farmers, either to compensate them for providing services and other support to occupiers, but also to provide for housing stock. So the state subsidizing farmers to create housing stock that on their farms without that being held as the property of the occupiers themselves. So there is a problem with ESTA Amendment Act, in my view. The Inter-Ministerial Committee on Land Reform is the committee of 6 ministers, chaired by Deputy President David Mabuza, who are mandated to take forward the recommendations of the presidential panel. As a member of the panel, I must say that we have not heard back from the Inter-Ministerial Committee. So since 2019, we have not been invited to a meeting of the Inter-Ministerial Committee or been informed of which of our recommendations they have now acted upon and which they have not and which they will not. So one of my recommendations for you to consider would be, are you going to ask the Inter-Ministerial Committee on Land Reform to report to you and to explain what they are doing about all of these recommendations? One area of progress that I mentioned briefly is the Minister of Justice and Correctional Services did prepare a memo to send to SAPS about the issue of registering violations of ESTA. I am not aware whether or not that memo was ever sent. So that would be worth checking. The new land court, the idea of a land court that has broader powers and mechanisms and mandate than the existing land claims court, I think is a step in the right direction. And the idea of having alternative dispute resolution like a land form of a CCMA could help. So there are intimations of some improvement. The Legal Aid Board has recruited Tabiso Mbense, who has been the key senior attorney at Legal Resources Centre, who has driven some of these important cases and is really an important and knowledgeable person. I think this is really the space where we could be looking at building training capacity, both for the attorneys and perhaps mechanisms of oversight over cases. What have farm workers and dwellers done since these 2 panels? Well, they've won 2 very important cases. They took government to court for not implementing the Labour Tenants Act and won in the Mvelase case, where it was clear that the state was in dereliction of duty in terms of the act. the court appointed the special master. This was overturned at the Supreme Court of Appeal, and the applicants then won at the Constitutional Court. And I think that this quote from the judgment is very powerful. For over 2 decades, the department has manifested what has seemed to be obstinate misapprehension of its statutory duties. So the functioning of the special master now on labour tenants, in my understanding, is very constrained in practice. Even though it has a strong mandate, it has very weak capacity, resources, and forms of coordination to help it to do its job. And I think that training through the special master of implementers is also crucial. Then also, of course, farm dwellers took government to court for not providing municipal services and won that case too, the Mshengu case, or what's often called the Pietermaritzburg case. 3 local municipalities that failed to make provision for the Section 27 rights of farm dwellers in the form of water, sanitation, and waste collection. So this was a case that presumably should have broader application because indeed it's quite clear that municipalities around the country consider privately titled land to be outside of their area of jurisdiction. And it's very important that Judge Mguni rejected this argument that municipalities don't have obligation on private land. So municipalities have to create plans, and I would imagine COGTA needs to, and SALGA would need to report on how they're addressing this issue at a national level. At the end of 2019, I must say, after all these panels and summits and inquiries, and the repeated pattern of identifying the problems, agreeing what must be done, and then not seeing those things being done, farm workers themselves approached through various local associations, committees, unions, and NGOs, approached both the Centre of Excellence in Food Security and ourselves as PLAS, 2 institutes at the University of Western Cape, and we held a major national conference on the future of farm workers, which is not only about implementing the law, but all the other changes that are affecting people. And I think that it would be useful, perhaps, for your committee to ask some of the key farm worker leaders who convened this conference with us to come and speak about specifically what they want. But I must say that the tenor of this conference was one in which people were saying government knows what we are experiencing, and government knows what needs to be done. And we have said this all before, and we were naive to think that if we tell government what is happening, that they will take action. So in many respects, I think that it would be a matter of rebuilding some trust with farm worker leadership who are really dismayed or seemed dismayed at the level particularly of how state officials are unresponsive when people want to enforce their rights. So certainly in the first years after Esther, the idea of rights awareness and rights education was the focus. Across the country, many farm workers know exactly what their rights are. They even know who is responsible, who is the duty bearer to address their rights in many cases. And yet they find when they try to invoke those rights, those officials are unwilling to respond. And in that sense, I think that the joint oversight by your 2 committees is incredibly powerful and could be even further strengthened by coordination with even some other committees. Some key demands and positions was about bringing parity to the minimum wages and enforcing them, stopping evictions and prosecuting farmers, absolute rejection of equity schemes as really a substitute for rights, making people shareholders of farms rather than confirming that they have rights to them, especially because these are prone to being manipulated. The demand for access to land for farm workers, often the idea that farm workers must be wage workers or they become farmers. But actually, access to land is crucial for poor people, particularly who have highly seasonal incomes, access to municipal commonage, fixing rural schools, and wanting to be visible, wanting to have a register of farm dwellers for IDP planning in every municipality. On the minimum wage issue, and I'm not going to go through, clearly the debates, the conditions of farm workers are profoundly influenced by both the very low level and the sporadic rise of the minimum wage, but also the ways in which employers have worked around this. So when the minimum wage, the sectoral determination that came into force in 2003 rose below inflation and was even static for some time, it was brought from a two-tier to a single-tier system in about 2008, I think, and then rose about 50% after the farm workers' strike. Interestingly and importantly, and I say this to the members of the Labour Committee, the predictions of mass unemployment resulting from the increase in the minimum wage were not realized. So there wasn't this massive job loss, partly because, according to many agricultural economists, a lot of the job shedding that could be done had already been done. Mechanization, substituting labor for technology and capital had already been done. So I think that the idea that keeping wages low will somehow improve employment is clearly not the case. The downside of this, and as many people talked about, particularly affecting women farm workers, is increased seasonality, increased labor brokering, and also the attempt of farmers as employers to work around the minimum wage by paying people hourly rates and reducing the number of hours per day rather than reducing the number of workers overall. So paying people for a 5-hour day rather than reducing overall. So people are caught in increasingly poor terms of employment despite the minimum wage, even where it is enforced. Finally, just to update around food prices, I want to mention the study that we conducted that does relate to farm workers on COVID and its impact on food systems that we conducted with colleagues across different countries. And in South Africa, and this is very important if we think about the living conditions of farm workers, we see that actually the conditions for hunger increased in South Africa dramatically between, this is April 2019, this is March 2020. So this is the start of hard lockdown. Oopsie, sorry. We can see the blue line. Inflation overall dipped dramatically at the beginning of lockdown as the economy closed. But food price inflation suddenly started taking off. So food price inflation has been overshooting general inflation ever since March 2020. And this has had devastating effects on all poor people, but also farm workers. We know from a long time ago that children growing up on farms are more likely to be stunted from malnutrition than other categories of children, even children in urban informal settlements. And this is the latest data we have from the General Household Survey. General Household Survey by Stats SA is looking at food insecurity among different people in different settlement areas. So the blue lines are the national average, and the orange lines are for people living on farms. And we can see across the board, people living on farms are significantly more prone to food insecurity, both in general and in the sense of limited food diversity, etc., than the general population. So it means that people who are producing our food are far more prone to hunger than the rest of the population, even the poor in other areas. And in the case of child hunger, it's nearly double the national average. And in fact, looking at farm workers, one specific study looked at seasonal farm workers in the Northern Cape. And the figures are truly shocking. So clearly, simply enforcement of the law is not going to be enough. And just to bring to an end, I wanted to reflect, and perhaps this would be a useful point of reference for your committees. Perhaps if you're wanting to take stock of what are all the many processes through which the problems of farm dwellers and farm workers living in working conditions have been identified, where they have been invited to come and tell their tell of their experiences, and where the state, Parliament, the Department, Human Rights Commission, and other bodies have made specific recommendations or specific commitments, because there's actually a vast degree of commonality across all of these. And what I would emphasize here, we have from 1996, 97, these two laws, the Human Rights Commission inquiry of 2001, a 2-year national commission of inquiry. Almost none of, in fact, I believe none of the recommendations were implemented when it was reviewed 4 years later. We had the Land Summit that had a huge range of recommendations and resolutions on farm dwellers and labor tenants, not implemented. The Farmworkers Summit was a national summit convened by Minister Nkwinti. So this was Minister Didiza in this period. Minister Nkwinti convened a national Farmworkers Summit attended by the president. Again, enormous extent of participation and input, far-reaching resolutions not implemented. The centenary of the Natives Land Act, parliamentary hearings, the department's symposium, 2 conferences organized by civil society at which government and parliamentarians participated, resolutions. The Land Tenure Conference of 2014 had 2 tracks, one around customary tenure, one around farm tenure, resolutions. The high-level panel, as we've discussed, the expropriation without compensation amendment that was promoted, the Presidential Advisory Panel, and then this National Farm Worker Conference of 2019. So that's the context in which I think your work now is located, where perhaps the question is, the question is not just about having another shopping list. The shopping lists of what needs to be done have been created repeatedly and to no avail. So I think that this discussion is about not just that, but who must do what by when, understanding that primarily the problems here are not legal. They are primarily political. There are legal problems, there are institutional problems, but primarily it's about implementation and enforcement. I would strongly suggest that it would be fruitful for your committees to consider discussing and establishing a reporting template, a format that says to the departments, the relevant departments and other bodies that report to you, here is the quality and level of detail that we want on specific things. Here is how often we want it. We want it in this format. We want it to be explained in this way, because I think that reporting on budget spent, number of hectares acquired, number of beneficiaries, this doesn't actually tell us the extent to which these substantial problems have been addressed. You need detail, you need specifics, you need progress on particular things. And this has been discussed before, and I think that there's a lot of goodwill from, whether it's from farm work organizations, NGOs, academics, to assist with developing such a reporting template if you wish to do so. And I'm sure the departments would also want to have some input. So it could be an exercise of agreement, to develop agreement on the forms of and formats of reporting. Because in fact, relevant departments extend beyond agricultural land reform and rural development and beyond labor. So it would be important to have other departments involved as well. So I raise that as a question as to whether your oversight will recommend further coordination beyond these 2 spheres. But beyond engaging with government and exercising oversight over the executive, there's a question of how to engage with farm workers and dwellers themselves. What's tended to be the case is that consultation by Parliament focuses on NEDLAC, which is clearly not an effective route for engaging with the issues facing farm workers, but also sporadic series of oversight visits. I'm wondering whether you would be interested to discuss perhaps a mechanism to engage the huge number of farm worker committees and others, many of whom are in contact with one another, they know one another, there's a whole sector out there, and are quite coordinated when there is an opportunity to get some traction, some leverage. So if you were open to that, I think that there would be a very positive response to have a regular and routine connection. And part of engaging differently could also be inviting them or inviting academics or lawyers and civil society structures to provide shadow reports when departments report to you, to always have shadow reports on their annual reports, on their budgets, etc. And then perhaps prioritizing a number of strategic interventions like getting the systems right for arrests for ESTA violations, just having the demonstration effect that if you break this law, there is a consequence, a process for triggering Section 4, and how to invoke this right of access to long-term tenure, consideration of expropriation and subdivision when receiving eviction applications. So this is both for the department, but also for municipalities, and establishing a mechanism and a framework under Section 25(5) to say, here's what the right of access to land means, including for farm dwellers. Chair, thank you very much for your indulgence. I'm very grateful for this opportunity. Thank you.
Thank you, Professor Hall. Honorable members, that is the presentation from the Presidential Advisory Panel. I'm opening the platform for interaction with the presentation. I'm on my attendance register. Honorable Briet, followed by Honorable Mukonto.
Thank you, Chairperson. Chairperson, maybe let me start by saying, and I appreciate Dr. Hall's recommendations on how us as a portfolio committee need to continue and need to go forward, and what we need to do. I think that was excellent, and I appreciate it. Chairperson, I would like to maybe make the recommendation that this committee, and maybe our portfolio committee specifically, needs to go and look at, because as the previous speaker mentioned, and as we've seen in our oversights as well, that we are having a lot of talk shops, we are having a lot of dialogues, a lot of promises are being made by government, and then we never have feedback, we never have report back on that. I think Ruth has now said it, these farmers, and we picked it up, these farm workers have frustration because what does it help I come to yet another symposium? What does it help I go to another talk shop? So I think we need to interact, and I would like to leave the suggestion here that the ministers should be called, and if we as a joint portfolio committee need to call the deputy president, I think that needs to be done, because I think we need a report back from the executive as to how far, and if I remember correctly, with this presidential report, presidential panel report, it was quite controversial, and there was a minority report that was brought out specifically in terms of that. So it is worrying that come almost 3 years later, we've not seen anything. So that would be my concrete suggestion, Chairperson, that we have the ministers and the deputy president come account to this joint committee so that we can see, and actually, as Ruth suggested, get a breakdown of what has been done. There were concrete steps taken. I think I would just like to find out from Ruth, I cannot remember correctly, were there timeframes specific to these resolutions included in the presidential panel report? And if not, would it be best to maybe see that, to keep them to account in terms of that? Chairperson, then I said, in terms of municipal services, I've made a note here that said they must deliver. We've seen a plight in the Eastern Cape, I specifically remember, Chair, where it was not even just a plight of the farm dwellers and the farm workers, it was a plight of the farmers, that everybody else is being electrified, everybody else is being assisted by the municipality, but it seems there was a lackluster approach by the municipalities to actually assist this farmer to not only for the farm dwellers, but for himself get electrification. So I would strongly advise that and have us have a clear resolution in terms of that. And as Ruth said, I think the court judgments were clear there. Chairperson, I think it's very good, and in terms of the fact that it was made mention that equity schemes don't necessarily work and that people need title deeds. I think that is something that we need to focus on. I think that was all, or they need land, access to land and title deeds, if I remember that correctly. But it was if I understood correctly, ownership is what is important. And I think we've seen that. I've always made mention in the Free State where people stay on land, but they never have ownership. Then when a person passes away, an elder, that land gets just redistributed to other people. And that is really something us as a committee needs to look at in terms of tenure security. And Chairperson, just something that I think we as a committee also need to take note of.
You wrap up, Honorable Member.
I will wrap up. Thank you, Chairperson. Is that I think we need to holistically look at the plight of farmers, farm workers, and farm dwellers holistically, because I don't think you can have the one without the other. And I think that is necessary. And I think to a large extent, legislation is not clear on that. But Chairperson, that was maybe just my inputs. Thank you.
Thanks, Honorable Briet. Honorable Mukonto.
Thanks, Chair. Let me welcome and appreciate the presentation from Professor Hall. Chair, it is very interesting to see how just one thing that sparked the whole debate. This debate and all these issues are sparked by the fact that the two joint committees went to the farms and just to do oversight on the living conditions of farm workers. But then it is clear now, Chair, that these issues are very broad, diverse, and deep-rooted. Hence, Chair, my recommendation will be one that it seems we don't need all these ad hoc interventions. To add to the recommendations of Dr. Hall, we need permanent bodies to deal with these issues. Maybe the issue of the land ombudsman, we have a lot of ombudsmen in South Africa, but I think we really need to have a land ombudsman, and also a land right courts with specialists in those courts, not units, because units might be subjected to reporting to bigger bodies that do not focus on the issues. Our courts are overwhelmed by issues of GBV, issues of illegal miners, issues, all the issues that our society is faced with. Hence, Chair, I'm saying I think we have tried all ad hoc interventions and ad hoc bodies to deal with this issue of a land. Now we need permanent structures. Thanks very much, Chair.
Thanks, Honorable Mukonto. Honorable Masipa.
Thank you, Chair. Prof. Ruth Hall and Prof. Klassen, thank you very much for this. Prof, I just, maybe the first question through you, Chair. The Esther, you mentioned something that just intrigued me to, determine from you. The Esther says the people that have been living on the farm for 10 years, and obviously they must be 60 years and older. So I think our challenge, we were finding young people that were living on the farms, and those young people were obviously sitting with the insecurity of tenure on the farms, and they were not working for the particular farms that they were staying on. I just want you to help with the clarity there. The other issue, Chair, really that I'm picking up with all these presentations is that, you know, there are clear failures from the Department of Agriculture, Land Reform and Rural Development. Not necessarily only failure, but I think reluctant of really doing what they're supposed to do. The Labour Department as well, you know, we found that it was really wanting. So the same that you have found, Prof. Ruth. SAHR, you know, the issue of lack of capacity there, we have discovered that they do not have capacity, they do not have the budget really to do their work. The police and justice, I don't really even want to comment on that. Now, my issue really that I've also picked up during and we will obviously be deliberating, is the possible disinvestments. Because what we have found there is that the poor road infrastructures in those areas or the farming community. Now, what you are having these challenges, and then obviously, you know, you're going to transfer the land. I mean, you're going to give the tenure right security as such. But the problem still remains that once you've given those people the tenure security, how are they going to survive in those areas where the farmers are really moving out and, you know, they are disinvesting and these people has to leave. So those are some of the challenges that I think will have to be addressed. The next point was that obviously I mentioned this one with regards to the farmer. So I think the question Honorable Briet did ask, and I asked with Prof. Klassen when she was presenting, to ask if there were no timelines that were given to the Parliament or to the department in terms of your study that you have done, your recommendations around, you know, the implementation of those recommendations. Because for me, it is important that, you know, we get to those kind of timelines to look at them. And whether, you know, are we going to really be seeing more court cases coming up with regards to these issues? Because, I mean, you have really made it quite clear in terms of issues that they needs to be addressed. You also mentioned the tenure grants and versus the subsidy. Which one do you say would you recommend is the best, and really why, you know, between the two, tenure rights and subsidy? Yeah, I also support the recommendation that we definitely need to call the Inter-Ministerial Committee to come and really engage us on really this issue of the land reform and rural development. The other part, you have really commented quite highly the Legal Resource Center. But I also think that the issue there is going to be capacity. Once again, I am not sure, but you can really talk onto that one. The municipalities, provision of water and other services. This is a problem, and this is what we've been picking up around the country. Whether there are any acts really that really help us in terms of addressing that issue, because I couldn't really find a way to really talk about, you know, how the municipality can enter those kind of situations where there is a farmer and obviously constructive evictions that are taking place, and obviously the workers there. The APP, I looked
Your
again
last
at the
question, Honorable Masipa.
Okay, the last part.
Yes,
Chair,
please.
I'm just wrapping up. The APP, Chair, I think, you know, the way we have got our APP, call it scorecard, clustering of food security, land reform and restitution. I think that has to really be something that we look at, Chair, to look at land reform and restitution alone, and also, you know, to start looking at this outcome and zoom in them, you know, a little bit much more broadly, because, you know, this thing of just saying, you know, we're just going to look at, you know, how many farms were given or commission is completed, how many hectares and so on. It doesn't really come to really nearly addressing the issues that we are facing with. Thanks, Chair.
Thanks, Honorable Masipa. Honorable Mdawe.
Thank you, Honorable Chairperson, and let's welcome the report by Professor Hall. Chair, just a recommendation from me. Can we therefore, based on what has been presented, get a consolidated report of all these recommendations, starting from the first summit or whatever it was called, or colloquium, whatever it is, all those recommendations be consolidated and then say, here is these recommendations per each of the aspects. Thereafter, engage as these two portfolio committees. After that, then we agree on the way forward, because there seems to be a lot of work that has been done since the dawn of democracy till to date. It's the question of whether do we have a consolidated plan of action for that to happen. If we can get that, I think we can find a first step towards the right direction. Thank you, Chair.
Thanks, Honorable Mdabe. I don't see any other hands. You're welcome, Honorable Mandela. I see you are back. I'm going to just pose my questions to the professor and hand over back to you to Chair Khosi Zwelivelile. Professor, I just have a few questions for you in respect of ESTA and LTA. Number one, what is your view around agri-villages? Because some people argue that government must acquire land and set up agri-villages where farm dwellers or farm workers could be based. We have seen in some cases that agri-villages can become dumping group of excess labor from farms. How do you take that one? Number two, there's attempts to improve tenure rights and redress the injustice of the past, included share equity schemes between farm owners and farm workers. Now in KwaZulu-Natal, we also saw examples of farm owner-initiated empowerment schemes. In view of the push for private sector partnerships in agriculture, do you think these schemes work? If yes, what makes them work? If not, what could be done to improve them, the share equity schemes? The third question will be on elaborating on the land rights protector. I'm slightly weary of the introduction of institutions whose responsibilities might already exist elsewhere, although not centralized. What would be the role of the land rights protector? How different will it be from the Human Rights Commission and the Public Protector? My last question, Prof. You touched on the mechanism of consultation. Do you think public hearings during consideration of bills and other committee activities are not adequate? That will be my 4 questions. And as I call you to the platform to deal with comments and questions from members who raised their hands, I'll be handing over to Honorable Mandla Mandela to chair the session further. Professor Ruthol.
Many thanks, Chair. Honorable Tlhape. So I think that there are some questions that relate to specifics. And I share the sense from the honorable members of the sense of like something different is needed. Something needs to be done differently. To respond on specifics, I think several people have endorsed the idea of calling both ministers of the 2 departments that we're reflecting on here, but also the Deputy President to report on progress from the Inter-Ministerial panel, from the Inter-Ministerial Committee. The question that we've been asked about long-term occupiers, let me say that. So ESTA is a very, very modest law. It doesn't say that farm dwellers have absolute rights to continue to live where they are. It says that there are rights and interests of both occupiers and owners. And that in the case of long-term occupiers, people who've been there who are elderly, they can't be evicted like once they're no longer useful for their employment, for their labor, and then basically avoid burials on farms by evicting people. But of course, as I said, even this is not enforced. It's widely flouted, even in those cases that go through the court system, which, as far as we understand, is a minority of cases. Yes, of course, young people still have tenure insecurity. Some would want to have tenure security where they are. They might want to have access to land for their own use. And I think it's important to understand that people's rights are being eroded underneath them, right? So when people are told, well, you can't keep cattle here, you can't graze here, you can't have family members come to visit, you can't come and go off the farm as you wish, you know, all of these rights get squeezed. So in many cases, people are living under worse and worse conditions. There are also massive violations of labor rights. For instance, people not being allowed to take employment elsewhere. So if you have a household in which only one person is employed, but there are other adult members who are not able to take employment on a neighboring farm or to establish their own small business, doing something where they are. This is a real contradiction in that people have entitlements as citizens and as residents of the country under the Constitution. They don't lose those rights because they happen to live on privately titled land. The interesting, question that comes to mind in response to some of your questions, which is like, should we do agri-villages? What about equity schemes? What do young people really want? Is, well, people must decide. I mustn't say, but what I can observe is that agri-villages have largely been driven either by farmers who are wanting to get state financing through which to evict people and yet have them conveniently close by. You know, so they've often been driven by the interests of landowners on externalizing the costs and externalizing occupation while still having a ready pool of workers. It's also been promoted by government institutions that want to resolve the problems of growing informal settlements around towns by trying to get farmers to buy in. So both the state and landowners are trying to shift the onus, particularly of not only planning but financing settlement solutions for farm workers. Farmers want the state to pay, the state wants farmers to pay, and they debate between themselves about agri-villages. The demand for agri-villages doesn't seem to come from farm workers themselves. And certainly when they do express a need and an interest to have their own land and yet retain the possibility of access to wage employment, their argument is always for agri-villages or any kind of arrangement where they have their own land, not just essentially an RDP house in the middle of nowhere, right? People don't want to be in a place where they are only, again and again, people have said, we want to not have to choose between small-scale farming and producing food because we can't afford food and having a job. We want to have both. And those options haven't really been available. But again, I think that it's the standoff between the state and farmers, neither of which wanted to carry this, rather than the interests of farm workers. On equity schemes, there have been several reviews, absolutely damning. In response to one of them, Minister Nkwinti placed a moratorium on new equity schemes. Farmers were up in arms because this has been a key way in which farmers are able to recapitalize their businesses with public money, right? So farms in crisis could sell off shares to their farm workers, getting state money while being able to continue with their normal operations. So the critical criteria for assessing an equity scheme is, firstly, has power really changed? Who is making decisions about investment and production and whether we should expand an orchard or pay out profits? So farm workers across all of the evaluations that I've seen, including the ones by the industry, for instance, the wine industry did one, Minister Nkwinti's department did one, they all say that power has not shifted, and that I think that less than 2% of the equity schemes had ever paid out any benefit. So there's no financial benefit. There's a theoretical benefit of being a shareholder, but if you don't get money and if you don't make the decisions, it's irrelevant, and it doesn't stop people from being evicted or losing their jobs. So to my mind, it's not a land reform measure. Equity schemes can be promoted through BEE, and farmers can choose to do them to increase their BEE scores, but they certainly shouldn't be publicly financed. And I will just quickly comment on a few other things. How should municipalities access farms? Well, this is precisely it. So the Pietermaritzburg court case on the access to basic services says municipalities must. They must have an action plan. They must know who lives on farms. Who are the indigent people in your entire territory, not just in urban areas? Who are the indigent people who need access to basic services? And you will need to make a plan to provide that infrastructure or negotiate with farmers, or if need be, register servitudes. You need to provide services. You need to have a plan to provide services to everyone in the jurisdiction. You cannot say that suddenly because people are living on privately owned land, they're no longer citizens of the state. Finally, I'm getting to the end. There was a question, how do we interpret failure? The total system is failure of, and particularly of the department to implement a law for which it's responsible, is, well, either it can't or it won't. My view is that to some degree, it really does seem there isn't the capacity. There used to be dedicated officials who were called ESTA officers that had absolute expertise and a sole mandate to implement this law. That also stopped, together with the training of magistrates and police, together with the ESTA task teams. This was also stopped in the early 2000s. So to the extent that there were any institutional mechanisms for implementation and enforcement, those were dismantled. Even though but there is a worry about, like, well, is it just a matter of don't have the budget or the institution, or actually won't? And the worrying thing here is that repeatedly we've seen the department appealing cases where farm dwellers have succeeded in litigation. So the state is actually asking the courts to let it off the hook. So again and again, we have to ask, whose side are you on here? I think that the pushing the onus back on farm dwellers to again and again go to the courts to ask for their rights, go to the courts to remind the state that they have failed to act. There's structural interdicts. We had the special master, there is a systemic problem that is deep-seated, but it's a systemic problem that is political at its base. And finally, on the land rights protector, Honorable Klape, the idea of the land rights protector emerged in the presidential panel because of the need to have an oversight to which people can turn when the institutions that are meant to address your rights and are meant to respond to rights violations fail to do their job. And also to do special investigations into patterns of abuse. The idea of a land rights protector, in my view, is made, well, the question that I think that you're asking is, would it be duplicating another institution's function? If we were to have a very functional land court with very effective and easily accessible systems of mediation and arbitration, alternative dispute resolution, where a farm dweller can say, this farmer turned off the tap and I can't access water, and that's a constructive eviction. Come, you must intervene here. And these are my rights. Can we agree these are my rights? Then that would be possible. But we don't have such a system, and the legal system is inaccessible to people. And I want to just end with an example of a former colleague who also did a master's with us and who is a lawyer and a former policeman, was once visiting a farm as an NGO activist at the time when people were being evicted. And they called the police, and the police came and said, well, what's going on? And they said, you must arrest this farmer for evicting. And the police said, well, we can't. And so literally, people are being told to their faces, we cannot enforce the law. We cannot enforce the law. So this is a law that farmers hate. Farm workers are fed up with this law because they don't believe in it, and the state doesn't seem to want to enforce it. So I think that, hats off to you for pushing. And I think that this renewed energy from your committees bodes very well I think that there would be enormous support if you were to go beyond public hearings. In my view, public hearings provide a sort of a litmus test in response to a particular piece of legislation, but they're not adequate for ongoing and more frequent and meaningful engagements that can help to track progress. So my view is that going beyond public hearings, for instance, if you were to have a small group of representatives of farm workers and those who study and work with farm workers across different parts of the country who routinely join to provide reflections in response to reports from the department. Now that we are on Zoom, it doesn't seem to even be a financial constraint to broadening out participation. And I would suggest that they would probably be very, very responsive to any opportunity to provide their responses to departmental reports. So in summary, I think that even if just 3 things were to come out of this process from today's discussion, firstly, calling the Deputy President on a report from the Inter-Ministerial Committee, calling the ministers to report on their progress, calling SAPS, perhaps the SAPS Commissioner, so those officials to come and report. Secondly, developing a reporting template. And I must say there are offers to support that and to support shadow reports so that when you have the department coming, you can engage more robustly and you have the kind of information you need. And then thirdly, developing proper training. And if Parliament were to champion that, I think that that would be a powerful intervention. Thank you so much, Chair. I think we have lost chair, so perhaps former chair.
I might have to take over, Chair. Where are you? Honorable Tabe? Doesn't look like she's here.
I see Honorable Slabe is here, but she's not unmuting, and I see Chair has completely disappeared.
She's giving over the government to us now.
You see, that's how it's going to be in 2024.
We are ready. We are ready. We are ready. But Nkosi is here as well. Honorable Mandela is here as well. So
I see he's just come back on. Yes.
Honorable Montreди. No, it's not here.
Chairperson, can you hear us?
If I may add, former chair, Hlape, asked one, oh no, it wasn't, it was Honorable Mdabe, said actually what would be useful is to consolidate all the recommendations that have been made over time. For instance, this recommendation was made in this year by the Human Rights Commission, and this year by a summit, in this year by a panel, in this year, you know, and perhaps, you know, I may be overstepping on behalf of colleagues, but perhaps that is something that we could assist with. If that would be useful, we could try to provide in a consolidated and summarized way, perhaps in a table, like here are the recommendations from which institutions, which years, which process led to that agreement. So that perhaps that would provide a basis when you have the ministers or deputy president or SAPS commissioner coming to report, that you have a basis to respond to them. So again, I want to emphasize a kind of a framework so that your oversight can be much more specific and you can be more demanding of specific answers from the executive when they come to account.
Look, Prof, that will help quite a great deal because I think now, as you were talking now and after I also listened to you, there's 2 things. There's Kgalema Motlante's high-level report, and obviously there's that presidential high-level report. So I myself was a little bit confused as to which one were you talking from and which one was the Dr. Claessens, you know, talking from. But I think it will be important to have a consolidated report and engage on those reports. Yeah. Agri-food. Looks like the chair and the deputy chair are on lunch now.
I'm here. I'm here, honorable members, not yet Uhuru. I think Prof has responded to all the comments and questions that were posed. At this point in time, honorable members, I would request Secretariat that we defer the manners that we're supposed to handle for today. We defer them to the next meeting, and so that I allow the members
Chairperson, we can't hear you.
that we adjourn this meeting at this point. Dr. Klassen, Professor Hall, members for fruitful deliberations. No point and defer the. Am I audible?
We keep on losing you, Chair.
Yes. Am I audible now?
We can hear you now.
Yes, I was saying, in the interest of time, I propose that we defer the minutes to the next meeting so that we adjourn this meeting at this point. I have thanked the presenters, Dr. Klassen and Professor Hall, and your good selves on the good deliberations on both panel reports.
That's progressive, Chair.
Thanks so much, honorable members. This meeting stands adjourned.
Many
Thank
thanks,
you.
members.
Thank you, Chair. Bye-bye, everyone.
Thanks, Chair.